Is now in session. Please be seated.
Yes, Mr. Scott. I might take the appearances.
May it please, I appear with Mr. Freeburn this morning.
Thank you. Ms Hogan-Doran.
Commissioner, today I appear with my learned friend Mr Varley and Mr Prosciutto for the Commonwealth. Mr Varley will take conduct of any public interest immunity issues that might arise with respect to the former ministers.
All right. Mr Beecham. Thank you. And Mr McCafferty. Thank you. Yes, Mr Scott, you're calling Mr Robert. Are you tendering exhibits first, or...?
I was wondering if we could have a not before time for Ms McGurk.
Oh, yes. Best guess?
12 o'clock.
Right, there you are.
Fully content with that. Thank you.
Thank you. Yes, are you tendering exhibits, or...?
Yes, Commissioner, before the witness is called, I tender the next exhibits on the list for this morning's proceedings from Exhibit 6270 up to and including Exhibit 6319.
All right. The exhibits 6270 to 6319 are admitted with the numbers they bear in the schedule. And now you're calling Mr Robert?
I call Mr Robert.
Mr Robert, will you take an oath or an affirmation?
I'll take an oath, Commissioner.
Thank you.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Scott.
Thank you, Commissioner. Mr Robert, could you please tell the Commission your full name?
Stuart Roland Robert.
Thank you. You were provided a notice to provide a statement and produce documents dated the 20th of December 2022.
Correct.
And you produced a statement in response to that notice dated the 18th of January 2023.
I did.
Are the contents of that statement true and correct to the best of your knowledge and belief?
They are, with one exception. I think Council has already spoken to you regarding an errant page in document SRO.001.001.005. Page 10 of that, for whatever reason, shouldn't be there and should be struck.
That's the PowerPoint slide from the deep dive session.
Yes.
I think you have 2 volumes of material there in front of you, Mr Robert.
I do, Mr Scott.
I believe it's the first volume, tab 17, is the deep dive session, exhibit 6280.
That is correct, and slide... That is part of work we did probably the following year, identifying the full range of cohorts. But it's certainly not part of the 4th of July pack.
You're presently a member of the House of Representatives, Mr Robert? I am. For the period 29 May 2019 to 30 March 2021, you were the Minister for Government Services.
And the Minister for the NDIS, correct?
Thank you. I'm going to start by asking you, Mr Robert, about the as incoming blue book that you commence your discussion of at paragraph 44 of the statement, page 13. Have that? I do. Now, the blue book is a term that's sometimes used to describe what's known as the incoming ministerial brief.
All the time referred to it, yes.
Thank you.
As opposed to the red book, which is for a new government coming in.
I see.
So a department should produce 2 books.
I see. I just want to ask you something you say about that blue book, which I believe is behind your tab 11. You have that there?
Tab 11?
Yes, I do. Exhibit 6276, doc ID CTH.4000.0034.6585.
Yes.
Refer to what appears on page 26 of that blue book under the heading Risks and Sensitivities in your statement. In particular, you refer in your statement to this being where you were informed about the Masterton litigation.
Yes, although I don't believe Marston's actually mentioned by name, but this is where I first came aware of a litigation issue.
Sure. You later learnt that the name of the applicant in the case was Miss Masterton.
Yes.
On page 15 of your statement at paragraph 48, you refer to receiving a brief mentioning the sensitivity of that proceeding that we've discussed, an Ombudsman report, and that only 10% of customers had been engaging in what was called the QP process. Do you see that?
Yes, brief 120, Cabinet in confidence, I do.
Thank you. The QP process, that's a reference to the process under the iteration of the Robodebt scheme then in operation.
Yes.
And when you say only 10% of customers had been engaging with that process, what do you mean by that?
The brief made the point that only 10% of customers that the department was engaging with were actually coming back and responding to the department.
All right. And is that in relation to those attempts by the department to contact those recipients of social security by reason of the discrepancy between the ATO, PAYG data and what they declared to Centrelink?
That is correct. So a subsequent Cabinet submission in May the following year when the decision was made to finalise it all.
Stop you there, I'm sorry. Are you referring to a Cabinet submission, Mr. Robert?
I am, but I'm going to refer to my personal notes that outline where the department said that they expected a larger number of people to engage with it, and that was the premise of the scheme. Here it shows that only 10% were, which I think was quite a shock to the department.
Could I ask that if you're going to refer to anything that might be Cabinet in confidence, you indicate in advance that you might do that, because there may be issues that the Commonwealth might wish to take in relation to public.
I can do that. I apologise, Mr. Scott.
Thank you. Sorry, I interrupted you. So only 10% of the customers have been engaging with the process in reference to only 10% of customers responding to attempts to contact them.
That is the brief that the department sent me, correct?
And is this right? The effect of the process was that if the customers did not respond, or I should say recipients of social security did not respond, they would have their entitlements calculated using averaged ATO data.
That is my understanding, yes.
I'm next going to ask you about paragraph 50 of your statement. You say, you refer to your first month of your second term as minister. When you say second term as minister, that's as Minister for Human Services in reference to the fact that you'd previously been the Minister for that department in an earlier year?
For a short period, correct?
Thank you. And when you say the first month of that second term, is that a reference to effectively June 2019?
It is. So if you think through the sequence, the 27th of May, I sit down with the Secretary Leon for 55 minutes, the normal welcome Minister, welcome Secretary, talk me through the issues. The Blue Book comes along. In the early June, there was brief 119, which is legal in confidence, to talk about all the issues with the scheme. Cabinet in confidence brief 120 that goes through where the scheme's up to and its architecture. And at this point, having just come from Treasury and having done over 30 bits of ledge in 9 months, and very attuned to how Treasury works, reading through it all, it became fairly obvious to my team and I that how Treasury works is fundamentally different to how Social Security works. And trying to pair the two is always going to be incredibly difficult.
Right. Well, you say that in this time you started to entertain doubts that the use of ATO averaged income data may not be sufficient to support the raising of a debt and that further investigations were needed.
Correct.
And you say that that was because social welfare payments were calculated on a fortnightly basis, whereas ATO data was annual.
Correct.
And you refer to your time as in the past as Assistant Treasurer, and that on that basis you were very familiar with the type of data the ATO would have had capacity to share.
Exceptionally familiar. Also being responsible for tech at the time, very aware of it. I used to use an example with my staff. We started doing this in defence when to solve problems you'd pick the left and right of arc of a problem and inflate it. And if those two held true, the centre will generally hold. So in this case, I'd often give an example where if for 25 fortnights of the year you earned nothing, but the 26th fortnight you earned $1 million. It's a somewhat ridiculous example, but it's illustrative. Well, in that case, you are entitled to welfare for 25 fortnights, but for the last fortnight you are not. But if you average it, the ATO will go, well, you earned $1 million in the year, therefore your taxable income is X, quite rightly, based on a sliding tax scale. But that data, when it comes across to social services, would say ostensibly you earned over $30,000 a fortnight. That's the effective averaging. So taking a difficult example like that and pulling it across shows very clearly this can't work. A better example might be a student who works over Christmas and then doesn't work during a period. But the more obtuse example highlights the issue of what happens when you use tax data.
That obtuse example is an example which you subsequently used, according to you in your statement.
I used it often with my staff, because my point in June, before I went on leave, was to say unless we can answer this question, we can't answer the question on how ATO data is used.
All right. And you went on annual leave from the 15th of June 2019 until the 22nd of June 2019?
That's correct. And I wanted a deep dive on the issue when I got back, because brief 119, which was legal in confidence, had outlined a range of issues that we were facing in terms of litigation. On the 27th of May, when Secretary Leon and I sat down, the very first meeting, she made the point that Robodebt was going well, her words, but there was a litigation issue. She said it had been mostly solved, but it may require some further advice and it may require some changes. So then I get brief 119, legal in confidence. I get a cabinet in confidence brief, which is quite extraordinary if you think as to why you'd put a brief as cabinet in confidence when I'm not working into cabinet on anything substantive. And at that point, we started going, we need to look at this.
Okay. So just to put this in the sequence, you received a brief which is behind your tab 13, doc ID CTH.0009.001.2893, exhibit 6075.
Yes, brief 119, that's right. So well, the first was the discussion with Secretary Leon, second was the Blue Book. This would be this or brief 120, I forget which came first, but they're the next two substantive pieces on this topic.
Okay, and we can see on page 2 of that brief, paragraphs 8 and 9, reference to report of the matter to the Office of Legal Services Coordination, the informing of the Solicitor General, close liaison of the Department with the Department of Prime Minister and Cabinet and the Department of Social Services.
As you'd expect for any significant litigation the department's facing.
Sure. And then there's a note in paragraph 9 about the potential implications of the litigation if the federal court makes a decision adverse to the position of averaging.
Correct. And then notes, of course, brief 120 refers on a detailed briefing on the budget measures, which is the other one I referred to.
Yes. Now, is it your handwritten notations under the words Minister comments on the box on the first page?
Yes, have DepSec briefed me on the first week of July, i.e. this is now really serious. Not only am I concerned, but the brief from the department saying that it is so serious that the normal way that significant matters are referred has been referred, and if there is an adverse judgment, well, it's going to have significant implications for the government.
Okay. And the deep dive session occurred on the 4th of July 2019?
That's correct.
And may we take it that your recollection of who was present at that session is as appears in paragraph 56 of your statement?
That is correct. That'll be drawn from the meeting invite in my diary.
Okay. And do you have a recollection of the Chief Counsel of the department, Mr. French, being at that session?
No, but the DepSec is entitled to bring whatever supporting staff they want, and it was quite common for a cast of thousands to turn up to these.
Okay. So is it possible that although you don't have a recollection of that being the case, that Mr. French was there, that in fact he may well have been?
Entirely possible.
Okay. And in paragraph 57 of your statement, is this right? You recount that you articulated to representatives of DHS your obtuse example that you described to us earlier regarding problems with averaging.
I wouldn't have used the word obtuse. I simply used it to you to give an idea of what I was thinking, but yes.
Sure, I wasn't purporting to suggest you use the word obtuse. It was just an easy way to refer back to what you said. And you say, paragraph 58, that you asked during the session whether there was any existing legal advice on the issue of use of ATO averaged income data, and you say that you were told no.
Correct.
You say that you wanted to know and ask those present whether the use of other data types could be utilised to improve the process. That's what you say at paragraph 59?
That is correct. So brief 119, which we referred to previously, indicated that if there are losses, well, there are substantial, as in if the federal court matter is lost, there'll need to be substantial changes to the design of the scheme. The same conversation, of course, was had on the 27th of May, where the Secretary was saying that some matters had arisen that may seem some design changes. Well, if that's the case, then let's have a conversation about what those design changes may be.
Okay. And then you describe what your state of mind was having heard the presentation at paragraph 60 of your statement, which is, you say you then held a strong personal view that the sole use of ATO averaged income data was insufficient to raise a debt, but was unsure if the partial use of ATO averaged income data was sufficient to raise a debt. For that reason, you decided that the next step to progress the issue was to obtain legal advice.
Yes, there would have been a discussion about it in terms of my staff unable to answer my obtuse, without using those words, example. My recollection is that there was little pushback in the room. Everyone agreed that we needed to get advice.
I don't want to be pedantic, but I'm not sure obtuse is the word you want. You mean extreme or exaggerated, don't you?
Yes, ma'am, that is a better choice of words.
Okay, thank you.
And it's your evidence, is it, as described in paragraph 61, that at the conclusion of the session you requested DHS seek a legal opinion from the Australian Government Solicitor?
That is correct. Might have said the Solicitor General, I can't recall, but I wanted some legal advice as to where we are, to the point where if I was right, and we'd sort of all come to the point now that we needed some legal advice, I can't walk into a cabinet room and say there needs to be changes without the highest level of legal advice in the land saying that's the case.
Okay. Are you now aware that, in fact, at that time, the department had in its possession a draft advice provided by the Australian Government Solicitor on prospects in the Masterton matter?
I've been so advised.
And that that advice dealt with the lawfulness of the use of averaging to calculate social security entitlement?
I've been advised that, correct?
Have you had an opportunity in preparation for your evidence today to review that draft advice?
I have not.
In your volume 2, Mr. Robert, tab 118, is a copy of that draft advice. It's exhibit 6314, doc ID CTH.3007.0023.8028. Have that?
In front of me? Yes, sir.
Thank you. Now, do you agree with me that would appear to be a draft advice from the Australian Government Solicitor dated the 27th of March 2019?
Yes.
And if you go to page 2, first bullet point, the top of the page, and for context, the words commencing at the bottom of the previous page says in relation to the bullet points that follow that the applicant presently has, and then in relation to that, or in that bullet point says good prospects of succeeding on the basis that apportioned ATO PAYG data does not establish that the applicant owes a debt under section, and it gives a section of the relevant legislation.
I see that.
And then if we go to page 11, in fact, if we start with page 10, you can see the heading apportionment as evidence of the existence of a debt under section 1223. See that?
I do.
And that you can see in paragraph 38, the paragraph commencing PAYG data has known limitations. See that?
Yes.
And then paragraph 39 talks about various inherent limitations with apportionment. To the effect that apportionment, which is being used here in this context as another word for averaging, produces inaccurate calculation of debts. Do you agree with me on that?
I do.
And then the point is made in paragraph 41 on page 11 that if apportionment does not produce an accurate assessment of a person's actual fortnightly income, then it does not provide evidence on its own that a person has received a benefit to which they are entitled so as to give rise to a debt under section 1223. You see that?
I do.
Now,
And can we add there's no statutory basis in the Act for deeming apportioned income to be accurate or to be a basis on which to raise a debt?
I agree, Commissioner. I'm a prolific Act reader.
okay. Now, appreciating this was in draft form, do you accept that it reflected the views of the authors of the document as at the date that it purports to be dated, that is the 27th of March 2019?
Yes.
Thank you. And on your evidence is that you weren't informed of the existence of this advice at the deep dive session on 4 July 2019?
If I can take you back, Mr Scott, if I may.
Sure.
This wasn't told to me by the Secretary on the 27th. It wasn't in the Blue Book. It wasn't in Brief 119, which covered all the legal aspects. It wasn't attached to, nor referred to, nor inferred of in Cabinet in Conference Brief 120. So on the 4th of July, what I'm hearing and seeing from you is that my department had an AGS brief, and they've now had it for 27th of March. Is that the date, sir?
Yes.
They've now had it for March, April, May, June. They've now had it for almost 100 days and have not informed me in writing in any way, shape or form. I do not recall this being briefed to me. I don't recall my department saying on the 4th of July, we have an AGS advice, because if we did, my actions would have been consistent with what I did on the 7th of November when the SG advice arrived. My department had had it for 7 or 8 weeks. I had it for 2 hours before I walked straight into the Prime Minister's office, unannounced, put it down and said, we need to stop this. That was my actions then. If I'd had a copy of this, or if someone had shown it to me, I'm not too sure if I or my staff would have got to the person first to take it from them. And then if I'd read that, I suspect my actions would have been the same as what I did on the 7th of November, as soon as I got the substantive brief from the Solicitor General.
I'm just going to put you the evidence of Mr French given to this commission as to what he said occurred at the 4th of July 2019 meeting, Mr Robert. He says that he brought with him a copy of the draft advice to the meeting, and he quoted directly from the advice at the meeting to raise verbally the need for a Solicitor General's opinion. So is it your evidence that you don't recall that occurring?
I don't, but of course, at the end of the meeting, my recollection is there was broad spread agreement we needed to get the Solicitor General opinion.
And he says that you said words to the effect to him that legal advice was really only an opinion until a court declares the law.
Again, I don't recall that, Mr Scott, but I again put it to the Commission. If I refer to the slides from the 4th of July, the ones where that errant page was, you know which page it's in, every deep dive a department has, they produce the slides for it. If you go to those slides, you'll find nothing about the AGS advice in it. So not only did the Secretary Leon not cover it on the 27th of May, it was not covered in the Blue Book, it was not covered in Brief 119, it was not covered in Cabinet and Conference Brief 120, it was not covered in the slides presented to me. Now, I don't recall it being briefed orally, but if the department had said, here is the AGS opinion, and it says that averaging is unlawful, I would have grabbed it and acted on it. More importantly, if I look at the PGPA Act, section 19(1)(b), I think, it makes it very clear that secretaries withholding information that is material from ministers is an offence under that Act. So if the Secretary knew that that existed and had not told me, then that offence may well be in play.
Can I, just for completeness, put this to you?
Yes, ma'am.
What the Secretary said was that she thought she or a staff member would have told you or your office of the AGS advice orally back in June 2019, about the time of the Masterton brief, I think, because they did not want to put it in a written brief. So can you comment on that?
I don't recall that, and respectfully, Commissioner, I dispute that. The whole point of Brief 120 is Cabinet in confidence is that it's Cabinet in confidence. It can't be FOI'd, can't be shared, can't be leaked, can't be doing anything. It's the whole point of you have things in Cabinet deliberation. If the Secretary had a brief that made it clear that the entire premise of a $4.4 billion program that had been running for 2.5 years under her watch, at least 3.5 years for the government, that it was now unlawful, the fact that that would not be given to me in writing is simply unconscionable. And I've chosen my words carefully, ma'am. How could a brief like that not be given in writing?
Okay, I think you've answered the question. You dispute the evidence.
Yes, ma'am.
Okay, thank you.
Given what you've just said, can you explain why an advice of the nature of the AGS advice on your evidence was not disclosed to you at this meeting?
No, I cannot. And I've since learned in the course of this proceedings it was not presented to the previous minister either. So there is a wider question, Mr Scott, if I may, as to why this advice in March wasn't presented to the previous minister as soon as it was received, was held over for the election, and then why the advice wasn't immediately put in writing to the new incoming minister. You could even ask the question why this wouldn't have been provided to the Attorney General.
Mr Robert, can I ask you to turn to your tab 24 of volume 1 of the bundles in front of you, exhibit 6284, doc ID SRO.001.001.0135.
Sorry, Mr Scott, you got ahead of me. Volume 1?
Yes, tab 24.
Tab 24. Which part, sir?
Well, I'll take you to it, but let's just identify it first. Do you agree with me that it's a transcript of an interview involving yourself and Laura Tingle on the ABC 7:30 program?
One doesn't tend to forget interviews with Laura Tyndall, Mr Scott.
I'm just going to ask you about the question and answer at the bottom of the page.
Page 1, sir?
Yes. So the question from Ms Tingle is, but the problem here is a more generic one about the Robodebt system, which is that people get assessments just saying you owe us X thousand dollars. It doesn't tell you when that debt may have been raised or what it relates to. Can you understand why people are perplexed and a bit angry about this? Do you agree with me that's a question that she asked you in this interview?
Indeed.
And that you responded, I certainly understand that, Laura. I always encourage people, if in doubt, contact the department. In the last 4 or 5 years, the department has recovered $1.9 billion in overpayments, and we have a legal responsibility to do that. So I guess it's a type of mutual obligation. People need to keep their affairs or their income assessments up to date. You know, using MyGov is one example, and of course we cross-check it with the ATO, and if there's a discrepancy notice is raised. And that's the legal requirement we've got. And if citizens just keep their income up to date, if there's any questions, contact the department. I think we can avoid many of these issues. Do you accept, Mr Robert, that what you've said in response to that question from Ms Tingle is inconsistent with the state of mind you assert you held at the conclusion of the deep dive session on the 4th of July 2019?
Yes, I do.
Okay.
Keeping in mind, if I've got a personal opinion, my next step is to seek the appropriate advice. Until such time as that arrives, I remain a Cabinet Minister and am responsible for holding the Cabinet line, which is what I've done in the interview.
Well, it's one thing, I suggest, Mr Robert, to be circumspect about a matter for which you've sought legal advice, I suggest it's quite another thing to represent a degree of confidence in the program that you appear to have represented in this interview.
Respectfully, Mr Scott, ministers are required to defend the government's programs as part of cabinet solidarity, regardless if they agree with them or not, as, by the way, is the public service. I've implemented many things that I passionately disagree with, but I'm still required as a minister to represent them and defend them. And that's what I've done here, regardless of my personal sense of belief.
Well, it's not just a question of personal sense of belief. On your state of mind that you assert existed from the 4th of July 2019, you had serious doubts about the lawfulness of this program.
My view was the sole use could not be sufficient. It just can't. Partial I wasn't well versed on, only because government has a way of adding bits and pieces together to make a whole. The tax office was a master at this. But at the sole use, yes, not just misgivings, it couldn't possibly work.
Couldn't possibly work lawfully, do you mean?
Correct, what I would call sufficiently. But just because I have a reservation, respectfully, does not mean I'm going to go on Laura Tingle's program and say I think the government program is wrong.
Well, you might not do that, but you might not express the degree of confidence in the program that you purported to in this interview.
In every interview, government ministers are expected to show confidence in the agenda of the government. There is no other way that the Westminster system operates. Cabinet ministers can't go out and defend some parts of a government's program and be wishy-washy on others. That's just not how a government can operate, sir, respectfully.
All right, the next document I want to show you is behind your tab 25, Mr. Robert.
Sorry, what number, sir?
25. Exhibit 6285, Doc ID SRO.001.001.0136.
An interview with Mr. Spears?
Yes, on the 31st of July 2019. All right, I'm going to ask you about the transcript of this interview, in particular the passage that commences on the page with the last 4 digits of 0004. And in particular, do you see the passage towards the bottom of the page, your statement commencing with the words, well, as of now?
Yes.
And then the words can continue there. But remember, David, since 1 July 15, there's been 850,000 compliance reviews finalised. In 20% of those cases, the citizens have said, no, here's all of my facts, and they've said nothing to see here. In 80% of the cases, the debt's been raised, and in 99.2% of the cases, the debt is correct. I suggest to you, based on your state of mind that you assert you had on the 4th of July 2019, that was untrue.
Well, we now know the basis of raising debts, as the SC or the Solicitor General has informed us, is incorrect. So yes, that statement is untrue. But until such time as that advice came and the use of averaging was continuing, that statement was in line with that.
Well, your evidence was that you could not raise a debt based solely on averaging.
That was my belief, yes.
And in 90% of cases, that's exactly what was happening under the program, to your knowledge at the time.
Yes, that is correct.
So what you said there, to your knowledge at the time, was false.
To my personal view, yes, but I'm still a government minister and it's still a government program, and this was the approach that Cabinet has signed off on 3 or 4 years earlier and had been going on. And until such time as I'm not a lawyer, I've got a competent legal view, it is still just my opinion.
Doesn't mean you have to misrepresent the figures, though, and say 99.2% of cases produce an accurate debt.
That's the figures from the department, Commissioner. In terms of the way they were operating, that's their numbers. Their numbers, I believe, that I was using in the House of Representatives about the same time. These interviews, I think, came about because of questions in the House of Representatives.
Commissioner, I object. This is clearly...
Oh, the numbers being used in the House. Yeah, stay off what you said in Parliament, if you wouldn't mind, because of parliamentary privilege.
Yes, ma'am.
But you're saying they were the departmental figures, but you knew they couldn't be right.
I had a massive personal misgiving, yes, but I'm still a cabinet minister.
Yeah, but it doesn't compel you to say things that you don't believe to be true, surely. It's one thing to stick to the policy and say this is how we do it and we're confident in the program, but to actually give statistics which you couldn't have believed to be accurate is another thing, isn't it?
They were the numbers from the department based on the working approach to how the program was being run. They were the accepted figures by government to use. And as a dutiful cabinet minister, ma'am, that's what we do.
Misrepresent things to the Australian public.
I wouldn't respectfully put it that way, because until such time, Commissioner, as I've got the legal opinion, I could be wrong. I'm not a lawyer, so my view may well be wrong. And having come from tax says black as white all the time. It's extraordinary what the tax office does on a commissioner declaration. So I've watched government do some extraordinary things. So I've got to leave room for the fact that I may well be wrong. The Solicitor General will determine the correct path, but until that time comes, I can't just give my personal opinion. I have got to continue to uphold the government policy.
This wasn't a matter of law, this was a matter of maths, really, and you could see that the maths could not be correct.
Well, the reason I used the extreme example, ma'am, to choose your words, of the $1 million was to try and stress test it. So in my view, the maths could not possibly add up.
Okay, thank you.
Thank you, Commissioner. The next document I want to show you, Mr. Roberts, is behind your tab 34. Doc ID CTH.3003.0001.1379, Exhibit 6318. Do you have that there, Mr. Robert?
Yes, sir.
Do you agree with me that's a transcript of a doorstop you did on the 17th of September 2019?
Yes, notwithstanding my name spelled incorrectly, but let's say yes.
Yes. Hopefully you won't attribute that misspelling to me. But do you agree with me that the doorstop that's being transcribed here is in reference to a class action that was being launched with an announcement involving Mr. Shorten?
Yes, my understanding is Gordon Legal had flown from from Melbourne to Canberra to do a press conference with Mr. Shorten just prior to question time.
Okay. And you open the doorstop by describing the class action as a political stunt?
I did. No case lodged, no papers, no plaintiffs. Flown to Canberra, Labor lawyers with Bill Shorten before question time, and in their press conference they said it was a legitimate political strategy. On the basis of that, I think stunt is probably the apt term.
This is the class action that the Commonwealth ultimately settled in the matter of Robodebt.
That is correct.
On the basis that the Commonwealth ultimately conceded that averaging was unlawful.
That's right, on the basis of the Solicitor General advice I'd asked for on the 4th of July.
Okay. And if we go to the second page of the document, last 4 digits, 1380, you're quoted in response to a question, do you concede that there is a high percentage of people who have been robo-debted? If I can use that word, where those claims were incorrect from the government. Do you see that?
I do.
And your response was not at all. We know there's been 850,000 Australians where the department has gone forward to say that the income that you declared to Centrelink on the left hand does not match your tax return on the right hand. Can you please explain it? 20% of those have adequately explained it. Of the remainder, 0.8% have been overturned on appeal. That's a 99.2% effectiveness rate for those who cannot explain why what they reported to Centrelink does not equal what they told the ATO on their tax returns. Do you accept from me, sorry, I'll withdraw that, I'll rephrase. Do you accept that your assertion of a 99.2% effectiveness rate based on the state of mind that you say you arrived at on the 4th of July 2019 was false?
I do accept that now. But again, Mr. Scott, as I said to the Commissioner, I am still at this stage a Cabinet Minister. I'm still required to uphold until such time as I'm advised lawfully otherwise, the requirement for the government program, I still have to defend it. That is the job I've got.
Despite what you knew to be the case, which is that you could not lawfully rely on income averaging as a sole basis to calculate and raise a debt.
Well, despite what I thought was the case, noting I'm not a lawyer and noting I've seen government turn black to white in the ATO before, whilst I couldn't reconcile the numbers, it doesn't mean I couldn't be wrong. And until such time as I've got the advice, respectfully, Mr Scott, I have no choice as a Cabinet Minister but to defend government policy.
Can I just ask you about this figure? Is that where the 99.2% accuracy rate comes from, the notion that only 0.8% had been overturned on appeal to the AAT?
Ostensibly, yes.
Okay.
That, and there'll be a whole range of other extenuating circumstances that might come up that vary.
Sorry, I don't understand.
In terms of 99.2% effectiveness for those who can't explain what they've reported, there'll be some cases in the AAT, there'll be some cases where there may have been an error by the department or an error by tax that may be picked up.
So what takes out the 0.8%? They've succeeded in the AAT, or the department of its own volition has said?
Yes, or they've found an error, or on review prior to the AAT, they've had a look at it. There'll be any number of these vagaries.
It's really hard to credit that it was only 0.8%.
That's the challenge and the problem of using averaging. Because only 10% of people were engaging with the department then simply got the ATO data, washed it through and said, voila, you've earned $1 million for the year. That's why the extreme example is actually quite a germane one to truly grasp what averaging does.
Look, on a bigger picture, you weren't the minister the whole time, but the government somehow has allowed this program to run in full flight since September 2016 on such flimsy premises. Is there anything you want to say about that?
Yes, ma'am. The premises are flimsy and they should have been questioned. Advice should have been provided. There were numerous instances where my legal team have shown through the Royal Commission where there are opportunities for legal advice to be asked and received. I still remain flabbergasted, I think, that on the 27th of May briefing, the Blue Book, Brief 119, Brief 120, Cabinet in Confidence, this AGS advice was not provided. If it had been provided and someone had walked in, I would have walked it straight to the Prime Minister.
But what about the ministers? They never had any responsibility to say, A, this just doesn't seem arithmetically sound, and B, what's the law?
Ministers are responsible and accountable for administering their department. I was. So I'm accountable for everything that my department did. And I'd like to think that I acted as soon as I found out.
All right, but do you take any responsibility for what the government of which you were part did?
Oh, absolutely, Commissioner. As a senior member of the government, I take absolute responsibility as part of Cabinet solidarity for this. But I also take responsibility for being the minister that called it out to say we've got to get advice and stop it. Now, I'd like to think that between when I asked on the 4th of July and when I got the advice on the 6th of November, that would have been shorter. I didn't think for a second that it would take a month for my department to agree what the wording is with the Solicitor General, and that may be naivety on my behalf. And I didn't think my department would spend 7 weeks holding the information up before they got it to me. If I'd perhaps known that would be that long, I may have done something to shorten it.
All right, thank you.
Thank you, Commissioner. Mr Robert, can you please turn to your tab 35, Doc ID ACS.9999.0001.0106_R, Exhibit 2948.
Is this where it says Cass and I met with Minister Robert?
Yes.
That would be ACOSS, is it?
Yes.
So this is an ACOSS file note, is it?
Yes.
Okay.
Now, this is a meeting on the 14th of October, file note of a meeting on the 14th of October 2019. See that?
I do.
Do you recall meeting with ACOSS representatives on or about that date?
I would have. It's ACOSS mostly is policy, so they meet with Minister Ruston, but as a general rule, I meet with anyone once.
Okay. I'll just call out the second and third paragraphs, please. Now, do you have a recollection on or about the 14th of October 2019 of a meeting where ACOSS representatives expressed concerns with the use of averaging in the Robodebt scheme?
Not vividly, but this wouldn't surprise me. This is how they would present themselves. So I don't dispute what they've put here.
Okay, and you accept that you said words to the effect that's recorded in the passages that are called out on the screen?
I don't recall at all, Mr. Scott. If I could make a comment upon it, I would have treated this, it's ACOSS, which means they would leak whatever is said straight away. I would have treated this as any media interview in that I would have held the government line.
Right, including saying you didn't think there was anything wrong with Robodebt as there is a duty to collect overpayments.
I can't recall the words I said, Mr. Scott, but I would have defended the program in line with media interviews I'd done previously.
Including saying you didn't think there was anything wrong with reversing the onus of proof.
Again, Mr. Scott, I don't recall it, but I would have defended the government.
Okay. And again, I suggest to you that's inconsistent with the state of mind you say you'd formed on the 4th of July 2019.
No, I agree with you, but again, for consistency, Mr. Scott, I'd say to you, as a Cabinet Minister, I don't get to choose the policies I agree with or don't agree with.
Do you think you said that people were better placed than Centrelink to get information from employers and banks and so on?
As a general rule, they are, Commissioner. One of the challenges is people don't keep their data up to date. For example, if you go to the Medicare system now, 2 million addresses will be out of date.
Okay, you may be wandering a little. I'm just asking if you said this.
Yes, I actually believe that people are the best place to update their information because they know which bank accounts they've got or which employers they're working with.
Yes, but Centrelink certainly knew which employers because that was the data it was operating off.
They would have got the tax data, yes.
All right.
Thank you, Commissioner. I next want to show you document behind tab 40, doc ID CTH.3035.0021.9581, exhibit 6290.
SG opinion, yes?
Yes. Of course, you recognise this document, Mr. Robert, correct?
I do, because I took it with me to see the Prime Minister on the night of the 7th.
And your evidence is that your office was not provided that document until the 6th of November 2019?
That is correct. That's when it entered the office.
Is it your evidence that you weren't informed of the substance of it before that date?
I don't believe so. I note Ms Leon saying that she put a phone call through to me on the 29th. I don't recall that.
I need to put her version of events to you for your response, Mr. Robert. She says, and has said to this commission, that she phoned you on the 29th of October 2019, informed you about the advice, in particular that as a result of the advice it is not permissible to raise debts based on averaging income. We have held this advice very close due to its sensitivity. DSS is not yet aware of it. We'll be preparing a briefing to you to inform the Prime Minister. Due to the timeframes in the Amato proceeding, we will need to act fairly swiftly to cease the averaging of income. The Department needs to take action in relation to the program and its ongoing operation. Do you have a recollection of, on or about the 29th of October 2019, Ms Leon informing you of matters to that effect?
I don't recall that. I didn't make a note in my diary. I'm a prolific diarist in that respect. My actions, if you look when this arrived on the 6th, I arrived into Canberra on the 7th. Department had it for almost 6 to 8 weeks. I had it for 2 hours and walked straight into the Prime Minister's office to put a stop to it. My contention to you, sir, would be if the phone call had gone like that said this is unlawful, I would have acted straight away.
Okay. I have to put the final part of what she says
Yes, sir.
to you. She says that you said words to the effect, legal advice is just advice.
Well, considering I'm the one who asked for it on the 4th of July, my staff chased it up. When it arrived within hours, not 8 weeks that my department had or my secretary had, within hours I walked into the Prime Minister's office to put an end to it and asked for an urgent ERC meeting which occurred the following week. So I think my actions go to my state of mind.
Can you please go to your tab 55, Mr. Robert, volume 2, exhibit 4263, doc ID CTH.4000.0070.266, sorry, .2611.
$55, 2611 is the last 4 letters, Mr. Scott?
Beg your pardon?
2611, sir, are they the last 4?
Yes.
Yes.
Now, do you recognise this document, Mr. Robert?
Yes, there were 2 documents to my recollection that arrived, 372 and I think 365.
All right. And is it your evidence that the date next to your signature on the first page of 6 November 2019 is an error?
Yeah, it would have been the 7th, I suspect, only because I wasn't in Canberra on the 6th. I arrived on the 7th.
Okay. And do you agree with me it's a brief to you about the Solicitor General's advice, the risks associated with continuing to administer the program in its then current form in light of that advice, and that the department will attempt to resolve the current litigation by way of consent orders?
Yes, I accept it says all that.
And on the second page, do you see that paragraph 3 identifies the critical conclusion from the Solicitor General's advice?
Yes.
And that paragraph 4, the department had not identified any errors in the opinion with which to re-engage the Solicitor General?
Correct. I made extensive notes in my diary on this.
And then under the heading Impact on Program, paragraph 7 commences with, whilst noting that the opinion does not amount to a judicial declaration of law. Do you see that?
I do.
Can you assist us as to why it would be necessary for you to be informed of what is a reasonably obvious proposition that the opinion did not amount to a judicial declaration of law?
Don't understand the question, Mr. Scott, sorry.
Well, you knew it didn't amount to a judicial declaration of law, didn't you?
I had a very strong view that the numbers don't add up. I'm not a lawyer, but if the numbers don't add up, they don't add up.
Sure. but
But I can't walk into Cabinet, sir, respectfully, and go, your numbers don't add up on a program you've been running for 4 years. But I can walk in with the second highest law officer of the land saying there is a substantial problem and this needs to stop.
just on the strength of that,
Second highest law officer in the land, Mr. Scott, absolutely. The only higher than that is the Attorney General himself.
with no further inquiry?
No. From whom do you seek further inquiry than the Solicitor General, apart from the Attorney General?
And is it your evidence that from the moment you received this, you were informed of this advice on the 6th of November 2019, you accepted the opinion of the Solicitor General?
I did, and the facts speak to it. Within hours, I walked straight into the Prime Minister's office, presented it to him, talked it through, asked for an immediate ERC as quickly as possible, which was granted, and said that we need to stop the use of averaging, all of which I informed the Secretary the next day. So my actions speak to how seriously I took this and exactly what I did. If I can compare actions, Mr. Scott, if you'd permit me, my department had this for 6 or 7 weeks, and I get a brief that goes through, here's all the issues the Secretary's got. They have spent weeks and weeks working out the liability the Secretary had before they gave this to government, noting they had the AGS advice that they did not give to me or to government. Within 2 hours, I acted. And that should give you a view as to the strength to which I held the view of the second highest law officer in the land.
By way of the liability issues of the Secretary that you're referring to, are those issues identified in paragraph 8?
They are.
See, one view of the evidence, Mr. Robert, is that the department thought it necessary to identify those issues because the Secretary needed to convince you to end the program because the Secretary perceived a lack of support from you in respect of that course.
I completely reject that, Mr. Scott, strongest possible terms. I asked for the advice on the 4th of July. I wanted it. My department took months and months to get it to me, and when they had it, they ostensibly sat on it for 6 weeks to work through what to do. And then as soon as I got it, I demonstrated the seriousness by walking straight into the Prime Minister's office. I'd also put it to you, sir, respectfully, that
You
on the
don't
27th...
have to put things to Mr. Scott.
Oh, sorry, ma'am.
He's not your adversary. He's just asking questions.
Yes, ma'am. I'll also like to state, if that's appropriate,
Sure.
That if that AGS advice had been presented to me on the 27th of May or in brief 119 or brief 120 at any of those opportunities, then that could have, or this issue could have been resolved earlier.
You describe what you did in response to this brief. May we take it in paragraph 84 of your statement on pages 26 and 27?
Sorry, what paragraph, sir?
Paragraph 84.
That is correct.
Including visiting the Prime Minister's office to personally discuss the Solicitor General's opinion with him.
That is correct.
With a view to a ERC meeting being urgently brought forward.
I needed an appropriate form of government, which ERC, as a formulated committee of Cabinet, will have the authority to sort this out.
Okay.
And it had a massive impost on expenditure to the Commonwealth. Therefore, it had to go to ERC before it went to any other form of Cabinet.
Okay. And you say in paragraph 86 of your statement that you met with the Secretary on the 8th of November 2019?
The next day, that's correct.
At the conclusion of the meeting, you instructed her to cease the use of ATO averaged income data as the sole or partial trigger for raising a welfare debt.
Correct. I explained to her the discussion with the Prime Minister. The Prime Minister agreed. We're going to ERC to resolve, but with the Solicitor General having said quite definitively, therefore, we needed to act.
Okay. I'm going to put to you her version of that discussion. Her version is that she said to you, in reference to the opinion, the best course is to apologise to our customers, to admit the error and to inform customers and staff of the steps we will take to correct the error. And you responded with words to the effect, we will absolutely not be doing that, we will double down. What do you say?
I don't recall that, Mr. Scott, and would be completely inconsistent with the fact that I've got the Solicitor General's advice I wanted. I've taken it to the Prime Minister. The Prime Minister's agreed to an urgent ERC. He's agreed to ceasing averaging solely and partially. That he wanted to look at further proof points, and the Cabinet deliberations from there also look at what those further proof points would be. I would have relayed that to the Secretary. The idea, somewhat farcically, Mr. Scott, if I may, that I'd come out of the Prime Minister's office, who's agreed with the Solicitor General's view, agreed to an urgent ERC the next week, that I would then ignore those two and say we're going to double down on the same project, doesn't make any sense at all.
Okay. I'm going to ask you about what you said earlier about the Solicitor General's opinion itself being sufficient to be accepted without any further inquiry. Paragraph 88 of your statement, you referred to the ERC meeting on the 12th of November 2019 and being in the Cabinet ante-room where you say you gave the Attorney-General an overview of the SG opinion and the OWN's opinion and asked him whether as First Law Officer he agreed with the views of the Solicitor General, and the Attorney-General responded that he did. I suggest to you that's inconsistent with your evidence that you accepted the Solicitor General's opinion without further inquiry.
If I may, Mr. Scott, ERC was set for the 12th. At this stage, the Cabinet Secretary walked out of the room to say they'd run out of time and the ERC meeting to talk about this would be moved to the 13th. We were all waiting in the ante-room. It wasn't a meeting per se, that's just where you wait to go into the Cabinet room. At this stage, I took the opportunity, now that we're delayed by 24 hours, to put it to the Attorney-General, and I called him Attorney, not Christian. So it was very clear to everyone in the room, the First Law Officer, do you agree with the Second Law Officer? And he said yes. At that point, I turned around to the assembled secretaries and made it very clear. The First Law Officer has now spoken. Obviously, the Prime Minister has now agreed. We don't have an ERC decision. We'll have that tomorrow. But this is enough in terms of the Prime Minister and the Attorney-General now and myself saying this finishes. So yes, we'd have an ERC, but the most substantial law officers, being the Prime Minister and the Attorney-General, have now spoken. It was a result of having the ERC moved to the following day. If the ERC had gone that day, no problem. The Attorney-General would have been in the room and he would have given his view in the room, and the same decision of the 13th would have happened on the 12th. But I wasn't prepared to wait that extra day.
I suggest to you, Mr. Robert, that your description of what you said to the Attorney-General in paragraph 88 is inconsistent with you having, prior to that moment, accepted as correct the Solicitor General's opinion.
And as I've just said to you, Mr. Scott, I reject that statement you've just made. The reason why I asked him was because the ERC meeting had been postponed to the following day and I didn't want to postpone it. I'd already had a letter written to Secretary Leon that I put into evidence, dated the 12th of November. I wanted to get that out and get that moving. And the easiest way short of an ERC decision was for the First Law Officer to speak so he could be heard.
Okay. But in any event, is it the position that after that meeting on the 12th of November 2019 that the position of the government was settled that averaging could not be used as a sole basis to raise debts?
The position of government is settled once ERC on behalf of Cabinet has settled it on the 13th, but at this stage now the Prime Minister and the First Law Officer, the Attorney-General, had also agreed with the Solicitor General, and that was enough to give substantial instruction a second time. I had already given it on the 8th that we are to cease. Secretary Campbell was also there. It was very clear now the Attorney General had spoken, but the 13th of November is when the government decision was officially made.
So that's when the position was settled, the 13th.
The position was settled on the 13th.
Could I ask you, Mr. Robert, to turn to your pay tab 61 in volume 2? Exhibit 6296, doc ID SRO.001.001.0141.
National Press Club speech.
Yes. On the 14th of November 2019. I'm going to ask you, Mr. Robert, about the passage from the transcript of that appearance, commencing on the page with the last 4 digits of 0017. Do you see there that the transcript reveals that there is a question from, at the bottom of the page, from Mr. Karp of The Guardian?
Yes.
Refers to the Robodebt program and comments by former senior AAT member Mr. Carney that Robodebts are illegal because you can't calculate a debt based on estimates of income. And he cites as evidence the fact that when welfare recipients appeal debts and appeal adverse AAT decisions, Centrelink folds its tent, it waives the debt and it refuses to fight the issue in court. So could I please ask if you're confident that the debts are legal? Why has Centrelink never defended them in court? You see that question from Mr. Karp?
Yes, I do.
And your response goes over the page. You initially say, I've never been asked by an NDIS participant about income compliance. The next page, you're then pressed by Ms. Lane to answer. And then you say, okay, I'll answer if you like. Almost 1 million Australians own $5 billion in debts, and Mr. Shorten made the point during the election campaign that no one gets a leave pass from that. So we have an absolute responsibility, including a legislative responsibility to collect debts. We have a responsibility to ensure that people who earn a fortnightly income, who receive a fortnightly payment, that payment is appropriate and that their income that they are reporting to the Commonwealth is actually real and tangible. So using averaging as the basis to say to a citizen there may be a debt, can you please engage with us, is entirely appropriate. And that process of averaging using ATO tax receipts to say to Australians that there may be a problem, please engage with us, is absolutely appropriate, and we have a responsibility to do that. Do you agree with me that the truthful response to the questions from the members of the press gallery at that point in time would have been to acknowledge that the government had reached the point where averaging was unlawful?
It may well be truthful, Mr. Scott, but I wasn't permitted to. So, if I may, the ERC made it very, very clear that any public announcement was to be agreed. I'm just reading my diary now. Announcement to agree with the Prime Minister, Treasurer, Minister for Finance and the Attorney General. I needed 4 senior ministers to agree with me before I said anything. So whilst I accept the contention that it had been resolved on the 13th, I did not have approval to make any statement. So I've answered Mr Karp's question very, very carefully, not to talk about the use of averaging.
But you've actually said that using averaging is entirely appropriate, and you could not have thought that for a minute, and you didn't need to say it.
With respect, Commissioner, if I may, I've said using averaging as the basis to say to a citizen, there may be a debt, please engage with us. At no point in this answer did I say use of averaging to crystallise the debt. I kept my words very tight because I knew the decision had been made. I knew I could not communicate anything about it. I'm asked a question, so I'm in a hell of a position now where I know what government's done, but I can't communicate it. So I've got to answer in no less a forum than the National Press Club in a way that says something and says nothing. It's a dreadful place for a minister to ever be in. That's why I tried to deflect at first, but Sabra Lane didn't let me.
Mr Robert, are you having reference to your phone during the course of your evidence?
I needed to bring up my diary. I can show it to you if you like, only because I didn't know where my diary entry was in this great stack of books.
I suppose it's a form of note,
Yes, Commissioner.
as long as you don't
Is that not
text
appropriate?
anybody in the process.
Oh, no, I'm happy to show it to anyone, and I'm happy to not do it. I just didn't know where I'd find my journal
Okay,
entry.
just let us know if you need to refer to it.
Oh, yes, ma'am.
And so we know what you're
I
doing.
apologise, Commissioner.
Okay, thank you.
Commissioner, would it be convenient to take the morning break?
Yeah, it would. We will come back at 25 to.
All rise. The Commission stands adjourned until 11:35. Royal Commission is now in session. Please be seated.
Thank you. Yes, Mr Scott.
Commissioner, just a matter's been raised with me over the break by Mr Roberts' counsel, and in consequence, can I just ask Mr Robert, can you confirm that the diary entries which you indicated you referred to in the course of your evidence, and which I asked you about, are those diary entries that have been already provided to the Commission by your lawyers?
Say that again, please, Mr Scott. I apologise.
The diary entries which I understand you were referring to in your evidence
Yes.
are the same diary entries that you've provided to the Commission?
Yes, they are. I just couldn't find them.
Thank you.
Commissioner, one of the diary entries which the witness referred to was one that had been redacted, we understand, by consent at the request of the Commonwealth. In due course, I'll make a non-publication order application over the part of the evidence referring to that diary entry.
Has something already been said?
It has.
Okay, but you're going to have to identify for me.
Yes.
Can you draw a non-publication order that covers the precise point?
Yes, Commissioner.
Thank you.
Mr Robert, can I take you back to the blue book behind tab 11 of your volume 1? Which is Exhibit 6276, Doc ID CTH.4000.0034.6585. And I'm going to ask you about a passage that is dealt with on page 25 of the document. Do you have that there, Mr Robert?
I do.
What I'm going to ask you about is the last bullet point under point 4 on that page. So if it could be on the screen, it's page 25, please, operator. If we call out that third bullet point under the point 4, commencing with the words the department is currently funded. Now, do you agree that this passage was informing you of consideration then being given to extending the Robodebt scheme to include what is referred to here as vulnerable cohorts, has been referred to in other contexts as sensitive cohorts?
If I may, I'll slightly rephrase your words, if you'll agree. The intent was always that they'd be included, but that Minister Keenan had stopped it. So the blue book here is saying that the previous minister had stopped what was intended to be included, and Minister Robert, if you don't continue it, you won't meet the savings. So we're saying the same thing, ostensibly, just with that slight proviso, if I may.
Okay, and can you explain what vulnerable cohorts refers to?
There's two ways to look at vulnerable cohorts within how Services Australia now deals with it. There's a vulnerability indicator you can put wrong a customer service officer can put on a customer's file, and it may be for any number of reasons. That they had self-harm, it had been escalated, there were some social health issues, or at the same time, the phrase generally came to be include also those, for example, who were remote or rural or disability support pensioners, and at times the phrase also included those of an age pension age.
So 65 and over?
Generally, yes, Mr Scott.
Okay. And now we understand your evidence to be that the advice that you were being provided was that if that cohort of recipients of social security were not included, that the capacity of the government to meet its savings targets with respect to the scheme would not be met.
That is the advice I received.
Okay. I'm just trying to find the relevant passage in your statement, but you, in your statement, express what you say was your views about this proposal were.
If it's madness, you're probably right.
Yes. So perhaps without reference to your statement, which I can't find the relevant paragraph for.
My view was there's no way we could continue this into vulnerable cohorts. Minister Keenan had stopped it. I don't know why. A question for him. To widen it whilst we still hadn't resolved the mathematical problem I had, I thought wasn't conscionable. So the view was to kick it into the long grass until such time as the question had been resolved.
And how did you document that approach?
By deftly manoeuvring the Cabinet Secretary to wait as long as possible whilst being pushed for a Cabinet document. And then at the last possible point where they're yelling at you, finally release a draft. And there's a process whereby there's a basic exposure draft, then it goes for cohort, then it goes for final. And at the same time, negotiating with the Cabinet Secretary that this was not appropriate for a whole bunch of reasons, and we should delay it. So the exposure draft was released, and then the Cabinet Secretary agreed to delay it, was pushed into 2021 year. That's my recollection.
Why didn't you do as Mr Keenan did and just say, not happening?
I recollect at the time I was getting a fair bit of pressure from the Cabinet Office that to meet the savings requirements this was needed, and that I needed to bring forward a Cabinet submission on this. And I recall, like advice from the Cabinet Secretary saying it must be brought forward. I again recall that I didn't have that same leeway that Minister Keenan had.
You were the minister. Could you not have said this measure just shouldn't be advanced and I'm not going to?
The Cabinet Secretary has a right to say you will bring this forward, and as a Cabinet Minister you must bring it forward, and that's why you've got to manoeuvre with the Cabinet Secretary to delay and negotiate with them for a whole bunch of reasons as to why it shouldn't. But you generally don't have the luxury of saying no.
So ministerial responsibility is subject to the Cabinet Secretary's desires?
Cabinet Secretary speaks on behalf of the Prime Minister, Commissioner. So if the Cabinet Secretary is not happy, the next call is coming from the Prime Minister.
Okay, so this is the Prime Minister's push for this sensitive cohorts expansion.
The process, how it runs, is that to meet the...
Sorry,
Commissioner, we are getting rather into the detail of the Cabinet process.
Well, I don't know. I want to know what the Prime Minister's approach on this subject was, not necessarily what he did in Cabinet.
Yes.
So
I'm very happy to answer.
that's what I'm asking.
Yes. Could I just take some instructions for a moment?
Sure.
The difficulty is the further this goes, the closer it gets to the personal views of ministers expressed in Cabinet. Now, I don't think I need to remind the Commissioner that those are the very core of Cabinet confidentiality and
Okay, well, there may have to be a ruling, but are you able to say the Prime Minister's approach outside Cabinet?
Yes, we're not yet in the Cabinet room. There's a requirement to bring forward all of the policy positions that government has said must be come forward, including all of the budgetary measures. And it was clear this was a budgetary measure, so therefore it was on the Cabinet Secretary's radar, had to come forward. Now, the Cabinet Secretary...
Okay, I did just ask you about... You were giving the impression at any rate that the impetus was coming from the Prime Minister, and I was just asking you, not disclosing any Cabinet procedure or discussion, are you able to say what the Prime Minister's...
Prime Minister signs off on everything that he wants to come forward.
Right.
And as part of that, the Cabinet Secretary actions the Prime Minister's requirement. So the requirement for me or any minister to bring forward a submission flows through that approval process.
Okay. From which I suppose we can join the dots, but...
So the Prime Minister would sign off on tens and tens and tens of submissions that through the process the Cabinet Secretary is required to coordinate ministers to come through.
This may be naive, but I would have thought when it was a portfolio like social services and human services, the Prime Minister would be guided by the Minister.
They are. Revenue matters, of course, are guided by the Treasurer in that respect. But the forward program of what's coming through so the Cabinet Secretary can coordinate what's coming to Cabinet at which time in the process for the budget formalisation is fairly set.
Right, thank you.
Thank you, Commissioner. Mr. Robert, if you could please turn to your tab 137 in Volume 2, Doc ID DSS.5000.0004.9783, Exhibit 6317.
Sorry, Mr. Scott, which tab?
137.
Tab 137 of Volume 2.
Yes.
This appears to be an article from The Guardian.
Yes. Recall at any stage reviewing this article?
I do.
Okay. Do you agree with me that it's an article dealing with, it would seem, leaked documents regarding the consideration of the expansion of the scheme to include sensitive cohorts?
It's not that it seems to be a leaked document. It is a leaked document, Mr. Scott. Yes.
Thank you. Can I ask whether this article had any influence over your attitude regarding the proposal to expand the scheme to include those cohorts?
No, it was just another leak out of my department, of which there were many.
Commissioner, there may be a need for a public interest immunity ruling arising from this line of evidence. I note that Mr. Beecham's client got a not before time of 12 o'clock. Mm-hmm. We're on 12 o'clock now.
All right, is there anything else you wanted to ask of Mr. Robert before we resolve perhaps just what can be put before the Commission on this issue and what can't?
No.
Right, well, we'll hope that Mr. Beecham is imminent. Is Mr. Gregory here? And so I think what we're saying, Mr. Robert, is that we'll have to sort out over the lunch break what should, because of the public interest immunity issues, you'll understand, what could or should be before the Commission, which means getting back you back after lunch just to finish off that question in case there are things that arise.
Yes, Commissioner.
So would you mind going away now and coming back, maybe a 2 o'clock start, I should warn you, if we're trying to get through things. Thank you. And we're a bit short of counsel generally, are we?
We are, Commissioner. I'm not sure what the status of Mr. Gregory is. We stand down for 5 minutes, Commissioner.
Sure. We'll just wait for Mr. McCafferty and Mr. Gregory, and also can we get the witness? It's Emma Kate McGurk, isn't it?
Yes.
Yes. All right. Thank you.
All rise. The Commission stands adjourned for a short break. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory. And we've got Mr.
Yes, thank you, Commissioner. I appear with Mr Freeburn. The next witness is Ms Emma Kate McGurk, who was previously released from her summons, I understand, and will need to be resworn.
All right. So we'll need you to take an oath of affirmation again, Ms McGurk. If you'd stand up for this, thanks.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Gregory.
Thank you. Your name is Emma Kate McGurk,
It is.
and you were served with a notice to give a statement and produce documents 0212 and produced a statement in response dated 23 February 2023.
I did.
You previously gave evidence, I think on the 22nd of November, is that right?
No, it was early November.
Just check that date. Sorry, 2 November 2022, that's
Sounds
correct.
more like it, yes.
In respect of two previous notices and statements that were served on you and you provided respectively. The first notice was NTG-0027 dated 18 October 2022 and your first statement was dated 21 October 2022.
That's correct.
And the focus of that notice and your response was on your request for Ms Pulford's legal advice in January 2017,
Yes,
in broad terms.
broadly, yes.
Yes. And the second notice was NTG-0068 dated 28 October 2022 and you produced a statement in response dated 31 October 2022.
That's correct.
And the focus, again, in general terms, was on the circumstances of your request for Ms Pulford's advice, whether the 2017 advice for Ms Pulford was communicated to the Ombudsman and whether any external legal advice was sought.
Correct.
Right. As you made clear last time, I think in your earlier statements and your evidence, your involvement in the online compliance scheme in late 16 and early 2017 spanned about 5 weeks.
That was while I was with the Department of Social Services.
Yes. And in that period, you acted for Ms Halbert, that is acted in her position 22 December 2016 through to 16 January 2017.
Yes,
And then the debt strategy, payment integrity and debt strategy section reported to you from 16 January 2017 through to 3 February 2017 because Russell de Berg was on leave at that time.
that's right.
Right. And following the 3rd of February 2017, you had no substantive involvement in the scheme or the response to the Ombudsman.
That's correct.
And by way of background to the statement that you recently gave, the topics in those notices did not require you to search through your DHS email records, which was where you worked in the means test section until 22 June 2015.
That's right.
Right. And you only had access to your Department of Social Services email records in the response that you provided to your 2 previous notices.
That's right.
And I think, as you say in your statement, you had regard to the emails you sent and received in that period from December through to February, December 2016 through to February 2017, when you prepared responses to your previous 2 notices.
I had access to the emails I could locate, yes, in that period.
Yes. Right. And you were able to locate emails during that period that were sent and received by you relevant to the meeting on 15 January 2017 in preparation for the Ombudsman's meeting the following day.
Yes.
All right. Now, the context of the meeting on the 15th of January 2017 was your awareness of an Ombudsman's investigation, which was initiated on or about 10 January.
The broader context was that Ms Wilson had been on leave. She was returning to work on that Monday the 16th. So there was a meeting on Sunday the 15th in order to brief her so she was ready for the meeting with the Ombudsman.
Yes, and that was a meeting you participated in and took notes.
I did.
Yes, of. And you understood at that time that the nature of the Ombudsman's investigation concerned a number of points, but one was adherence to relevant legislative requirements.
Yes.
And another was the accuracy of debts being raised via the platform. I'll take you to the document. It's behind tab 26 in your bundle, exhibit 3601, DSS.5113.0001.0052.
Sorry, behind tab 26?
27, my apologies. You'll see that that is an email where the title of the document is Commonwealth Ombudsman Own Motion Investigation Notice.
Yes.
And Ms Patton sent it to yourself, Mr Herman, Mr Knox on 11 January 2017.
Yes.
And behind tab 28 is exhibit 3603, the attachment which is the notice to the Secretary of matters within the scope of the investigation.
Yes.
And you agreed with the first dot point, but you were unsure about the second, that is the accuracy of debts being raised via the platform.
I can see that now, thank you.
And I think that in your position, correct me if I'm wrong, yourself and Mr Herman had a degree of responsibility for organising a number of features about the scheme and related extensions of the measures in January and February 2017.
Yes.
And can I take you to tab 70, exhibit 3610. It is an email from Mr Herman to you.
Sorry, tab
70.
70, sorry.
That's all right.
Yep.
It's an email, yes, it's on the screen. From Mr Herman to you, attaching a document called the PAL Input Social Security Stream Action Register week of 23 January, and it refers to his input into the action register. You can see that?
Yes, I can.
All right. And if you go to tab 71, you'll see the attachment, exhibit 3611. And it's the action register which was updated as described by Mr Herman, and you can see markup in the document consistent with his additions or alterations. For example, the crossing out of Gary Knox and the addition of Rob Herman in Action Officer in line 1. You see that?
Yes, I can see.
Right. And in the first column under the heading Subject Task, there is a reference to the Commonwealth's own motion investigation, that is the Ombudsman's investigation, and the key component was concerning the DSS relates to adherence to legislative requirements.
Yes.
And you and it would seem Mr Knox were initially responsible as action officers, but Mr Herman added himself on or about the date of the previous email, which was the 1st of February. Does that accord with your recollection?
Certainly, the reason Mr Knox was working on it was because I believe Mr Herman was on leave, so that would make sense.
Right. And if we move to the action item and the status and comments item in the same row, you can see that when originally drafted, the action was that the Ombudsman's office has requested a meeting, presumably with the department, and that's been updated to indicate the department is waiting for request from Ombudsman's office. And that reflects that the meeting took place on 16 January 2017.
Yes.
And also indicates that the first draft of this document was prepared before that meeting.
Yes.
All right. And it was then in the context of an awareness that one of the primary concerns for DSS, insofar as the Ombudsman's investigation was concerned, was whether the scheme adhered to the legislative requirements.
Yes.
All right. If we go back then to the chronology, after you received the copy of the Ombudsman's notice on 11 January, on the 12th of January, behind tab 33, exhibit 3602, Mr Herman, Ms Halbert, you'll see, sent yourself and Mr Herman and Mr Knox.
Sorry, which tab?
33. It's also on the screen, if you just want to double check. It's a document entitled Forward Legal Advice, Data Matching Notifications and Debt Raising.
Yes.
And in the middle of the page, you can see an email from Ms Halbert to yourself and Mr Herman and Mr Knox, 12 January 2017, which forwards the sequence of emails below.
Yes, I do.
And the crucial part of the email was the legal advice by Simon Jordan, which commences at the bottom of the page, 18 December 2014, which was a second counselled by Ms Pulford. Do you see that?
Yes, I do.
And the advice included the factual context in which that advice was sought over to the following pages, .0003 and .0004.
Yes.
And you no doubt appreciated that as at the date you received this document, 12 January 2017, you were aware that the earliest advice, in the terms that it was proposed to DSS in 2014, were said to not fit within the legislative requirements for raising debts.
Yes.
You set about gathering as much information as you could, I take it, in preparation for the meeting on the 15th of January, which was itself preparation for the meeting with the Ombudsman on the 16th of January.
Yes.
One of the things that you did is behind tab 36, exhibit 6341, and this was the same day you received the 2014 advice, was you obtained copies of online compliance letters from Ms Alison McCann.
Yes.
That's right. And Ms Alison McCann was, at that time, I think, employed in the Department of Human Services.
Yes.
And you will see behind those tabs, we don't need to go to them, the copies of the 5 letters which were developed in respect of the identification of discrepancies and raising of debts under the scheme.
Yes.
And on that date, you forwarded those letters to Robert Herman, Ms Halbert and Mr Knox.
Yes, I did.
All right. And you had at this point already received copies of DSS policy advice in respect of the scheme as it was first proposed in 2014 and 2015.
Yes, I had gathered some information from Mr Joyce early in January.
Yes. I'll take you to those documents. Behind tab 19, you'll see Exhibit 6374. An email from Mr Joyce to you dated 5 January 2017, where he says, FYI, as discussed. The document is DSS.5075.0001.0127. And you can see from the email trail that it came to Mr Joyce initially on 7 November 2014. If we go to page 2.0128, on the 7th of November 2014, a person whose name is redacted sent the email to Cameron Brown, Mark Jones, and copied in Mr Joyce, Mr Cavalli, Ms Pulford and Ms Foster. You see that?
Yes.
And the advice from this person, you'll see on the next page, from the footer, he held the position of Acting Director, Rates and Means Testing Policy Branch within the Department of Social Services.
Yes.
And you knew that person to be David Mason?
Yes.
Right. Now, what was very clearly conveyed in this email was that as at November 2014, Mr Mason set out in detail reasons why the proposal was flawed, which included the fact that the calculation method did not accord with legislation, which specifies that employment income is assessed fortnightly, and that it followed the debt amount calculated could be incorrect according to law. And there were other policy flaws in respect of the proposal identified by Mr Mason.
Yes.
And would you agree that those policy flaws and the reference to the legislative flaw that is referred to in that email by Mr Mason are flaws of some substance?
Yes.
And you appreciated that at the time you received the email?
In 2017, yes.
And you appreciated that because your period of employment up to 22 June 2015 at DHS was in the means testing branch.
Yes.
And so you understood exactly what was talked about in terms of the corresponding office holder at DSS. These were not foreign concepts to you.
No, the fortnightly income test was central, yes.
And if we move then to the bottom of the page, the first page, .0127, you can see that although it's redacted, it's from Mr Mason to Mr Joyce, 21 December 2016, and he describes what follows, that is, his 2014 policy advice. And he says it's not clear what form this measure was ultimately implemented. It seems like when a discrepancy is uncovered that the customer is contacted and given the opportunity to clarify and provide fortnightly income amounts. It's not clear, however, and he continues to identify 4 points which flow from his earlier advice. Would you agree?
Yes.
And they included the difficulty in calculating fortnightly income by reference to the ATO income details, which is unclear whether that was in respect of a specific period or for a financial year.
Yes.
And 3, whether if the customer does not respond or does not have information about their fortnightly earnings, is a debt raised on the basis of averaging. And then 4, he, over the next page, raised a legal question, what a tribunal's view of debts being raised based on averaging would be under social security law. A fortnightly income test applies. You see that?
Yes.
And if we go back then to the first page, you can see that Mr Joyce, after receiving the email on 21 December 2016, sent it to Mr Whitecross and Ms Davis. It appears in response to a request from Mr Whitecross.
Yes.
And in that email, he indicated that he would send a further email, which was sent to Mr Whitecross, that confirms that legals have provided advice on the DHS proposal. See that?
Yes.
All right. I'll come to the further email shortly, but there is an indication in the very first line of Mr Joyce's email to you that there was a discussion between the two of you. What can you recall of that discussion?
I don't specifically recall the discussion with Mr Joyce.
Right. Do you generally recall it?
Only I was prompted to recall that I had had it when I reviewed the material for my first and second statements.
And what did you recall following that prompt?
Just that I'd gone to Mr Joyce and asked him for any information he could provide on advice that had been previously provided on this matter.
And why were you asking that question in advance of receipt of the notice of the Ombudsman's investigation?
So my memory is that in early January there were a number of media interviews that the Minister did, and it was in relation to that.
Right. The next email sent by Mr Joyce is Exhibit 2107. It's behind tab 25. And it was sent about a minute after the email we've just looked at. And again, you can see the sequence where Mr Mason sends an email to Mr Whitecross and Mr Joyce on the 16th of January 2015. Mr Joyce sends it to Mr Whitecross on 21 December 2016, and then Mr Joyce sends it to you on the 5th of January 2017.
Yes.
And this was Mr Mason's advice as at 16 January 2015 under the title Information about the DHS proposal to change the approach to identifying and raising debts. You see that?
Yes, I do.
And if you move to the second page of that document, you'll see at .2173 the DSS concerns. The first dot point refers to the advice of the Public Law Branch, which you understood to be a reference to Ms Pulford's advice. Sorry, Mr Jordan's advice, second counsel by Ms Pulford.
Yes.
And the balance of the concerns related to policy matters and accuracy matters.
Yes.
And so when you arrived at the meeting and I appreciate it was a telephone conference, on 15 January 2017, you were not aware of any legal advice or policy advice from DSS which supported the method of averaging income by reference to ATO PAYG data.
So could you just repeat that, please?
By the time you arrived at the meeting on 15 January 2017, you were not aware of any DSS legal or policy advice which supported averaging in the raising of debts by reference to PAYG data.
Yes, that's my recollection.
Right. Aware as you were of the main issue for DSS, and that is the adherence of the scheme with legislative requirements, surely there was some discussion about the fact that DSS had not identified a document containing advice which supported the scheme.
So I can't recall particular conversations to that end. Certainly all of the information you've taken me through we found at the time and was supplied to the group of people participating in the meeting.
That is, you don't recall, I take it, any discussions about this central question about where's the advice which supports the scheme? All we've got is advice contrary to the scheme.
I don't recall any specific discussion to that end.
Any general discussion to that end? Surely it must be spoken of.
Well, I'm aware there was a discussion that led me to seek Ms Pulford's January 2017 advice. So I accept there was a discussion about advice, but I don't recall any specific discussion.
As I understood your evidence and your statements, the discussion that led to you asking Ms Pulford for advice in January 2017 occurred after the meeting with the Ombudsman on the 16th of January.
Yes, that's to the best of my recollection.
All right. I'm asking you particularly about conversation on 15 January in preparation for the meeting with the Ombudsman.
Yes.
About the fact that you had only uncovered policy and legal advice which was contrary to the averaging concept.
So, as I said, I don't recall a specific discussion about that. The meeting on the 15th, which I only really recall via prompting from my notes, seemed to focus on representatives from the Department of Human Services telling us how they were implementing the proposal.
Right. So you don't recall any discussion prior to the meeting between yourself, Ms Halbert, Ms Wilson, Mr Kimber and Mr McBride about how there was no legal or policy advice supporting the concept of averaging?
I can't recall any specific discussion.
Or general discussion?
Well, they may well have been, but I can't recall it.
Just can't recall.
No.
Can I take you to Exhibit 2105? It's behind tab 46. This is an email sent by you to Ms Halbert, Ms Wilson, Mr Kimber and Mr McBride before midday, Sunday 15 January 2017, where you attached some documents in preparation for the teleconference later that day with DHS. And you can see from the email that these were documents you scanned in to the system in order to send them as an email to DSS participants.
Yes, I do.
Right. And if you go to tab 47, Exhibit 2106, you will see those attachments.
Yes.
And again, they are various versions of the legal and policy advice from 2014.
Yes.
And they include I'm reminded I didn't tender any documents at the start. I'll complete this question. The email by you was intended to bring everyone at DSS up to speed on the information that you had gathered prior to that meeting.
Yes.
Do you want to tender 6374 through to 6377 in accordance with the list of which I know?
Commissioner, it's actually 6320, the whole of the material for Ms McGurk. We've had that checked.
Oh yes, thank you, 6320.
6320 to 6377.
Just bear with me a minute. I thought we already had in up to 6373 this morning. No. Okay. Sorry. Okay. Very well, then those documents are admitted with the numbers they bear in the schedule.
Thank you. And as those documents made clear, at least as at December 2016, one of the authors of the policy advice, Mr Mason, was unclear quite what was implemented and whether there were any obvious issues arising from what had been implemented.
Mr Mason
Yes.
said that, yes.
Yes. All right. And as you also said a short time ago, the focus of the discussion was on the information provided by DHS about how the scheme was implemented and the reference to averaging as a last resort.
Yes, that, as prompted by my notes, that was what the Sunday meeting was about.
Yes. And it was in that context you gave evidence on the 2nd of November 2022 in respect of when you first became aware that averaging was involved in the PAYG measure.
That was my understanding when I prepared the statement and when I gave evidence.
Yes. And to some extent, that has changed because your attention is now drawn, or was drawn to, a document authored by you in May 2015.
Yes, that's correct. I did, in my first statement, refer to a discussion I recollect from 2014, but we discussed that in my previous evidence. But certainly the material that was provided to me recently has caused me to reflect.
Right. And we'll come to the 2015 document shortly, but do I understand your third statement in respect of the 2015 document to convey that even though you authored the document, you don't now recall the circumstances in which you sent that document?
So that's the May 2015 email. I don't recall the meeting that's described in that email exchange,
yes.
Nor do I recall having sent that email.
That is, you still don't recall sending that email?
No.
The context then in which you gave specific evidence on the point in November last year, perhaps it might be convenient to go to the transcript. It is behind tab 89, transcript page 283. Sorry, 284.
Yes?
And you will see at the top of the page the question and answer. And in your answer, you convey that we, that is DSS, understood from the material that we gathered that Human Services had not amended or didn't find a reason to amend the way that income was assessed and debts were raised. And if I pause there, Mr. Kimber had sent you an email in January 2017, 15 January 2017, in which he referred to a meeting with persons from DHS on 27 February 2015, where he was assured that the way income was assessed and debts were raised would not change.
That was one of the pieces of material we were relying on for that at that stage.
Yes. And what you conveyed in answer to that question was that it was the understanding of DSS that DHS had essentially taken on board the 14-15 advice and made a change to the proposal so that income, and there was no alteration to the calculation of income and therefore debts.
That's what the material we were looking at led us to believe, yes.
The reference in the final sentence to the piece of information was essentially set a new concept to us, this idea that it would be used where there was no other information available. You're referring there to what was communicated by DHS representatives in the meeting on 15 January. Is that right?
Yes.
And that's what's clarified over the balance of that page of your evidence. And the following page, where you'll recall you were asked questions by the Commissioner. You see it about line 21, and what did you think they were doing then, not averaging at all? And you said, well, at that point, so I was new to this, Ms. Halbert was new to this. We were relying on a few documents that we were able to pull together. From those documents, we understood that the initial advice that the Department of Human Services had taken on board and were implementing a system in accordance with the legislation. so that the way income was assessed and debts were raised, there was no change to that. That was our understanding. You see that?
Yes, I do.
And you can read for yourself the balance of the questions that were asked of you by the Commissioner and your answers through to the bottom of that page and over through the top of the next page. You see that?
Yes.
And I take you particularly to my question at line 17. And did your understanding then shift, as you say, in the meeting with DHS, where they said nothing has changed, but we do use it as a last resort? And you said, so that certainly was not a piece of information that I can see in any of the documents we had to inform ourselves prior to that meeting, yes. You see that?
Yes, I do.
All right. And did you give that evidence honestly?
Yes, I did. That was based on my review of all of the emails that I had searched, refreshing. I mean, I was basing it on the documents that I had seen. I didn't have a lot of independent recollection, and that evidence was based on the emails at that time I was aware of.
And the only emails you had available to you at that time were the emails from your Department of Social Services account?
What was sitting in my archive, yes, that I could search.
And as you said in your statement, you searched those emails that you sent and received during that period?
That I had sitting in my archive, yes.
Yes. And did it appear to you when you searched your emails for those 5 weeks that it was a complete set?
I suppose I didn't consider about whether it was a full set or not at the time.
It didn't strike you that that was something that was relevant at the time?
It was a possibility. I was only searching what was available to me.
Yes. The other aspect of the evidence that you gave is over at page 287. And it was in response to questions by Ms Hogan-Doran where you conveyed from about line 7 that when you were preparing your statement, you remembered that in 2017 you remembered a conversation with Mr Ryman in 2014.
Yep, that's what I recalled, yes.
Right. And the conversation in respect of Mr Ryman was that he was asking you about a question of income calculation or something to that effect, and you advised him that he should seek advice from the Department of Social Services.
My recollection was that Mr Ryman was talking about a new proposal they were putting together that involved calculation of debt using ATO data, and my recollection was that I directed him to seek policy advice from the department, yes.
And that was the only recollection you had of prior involvement with anything that might relate to the OCI scheme?
At that time, yes.
Yes. All right. Can you turn to tab 15, Exhibit 6331. This is the email sent by you on Friday, 1 May 2015, when you were working at DHS
Yes.
as a Director of Income Support Means Test. And as you said earlier, you don't recall the circumstances in which you provided this.
No, I don't.
And you, even though it's been drawn to your attention, you don't recall the context in which you were being asked for your position on it,
Well,
apart from what is contained in the document.
apart from what's in the email itself, I don't recall this meeting.
All right. And to be clear, in the trail, and the document extends to 2 pages, the first email is from Danny Scott to you, copied in to Ms Collins, proposed PAYG process 1 May 2015. Now, were you aware that the budget was to be announced on the 12th of May 2015?
I would have been, yes.
All right. And what is set out there is the proposal about the way that the Policy, Strategic and Business Solutions Customer Compliance Branch Business Integrity of DHS were proposing to use PAYG data in the calculation of historic debts.
Yes.
And you can see that points 1, 2 and 3 involve sending of a letter outlining the information, that is, the matched data details such as the name of the employer, period of employment, amount of income earned, information declared by the customer and the discrepancy to ensure the customer is fully aware of what is intended to be discussed. There was no suggestion to suspend or cancel customers for failing to respond to the initial letter. If the customer failed to contact the record, that is the customer's record, would be updated with information from the match, and then the customer would be notified of any debt through existing debt notifications. You see that?
Yes.
And there was a variation to the circumstances in point 2 which might lead to the calculation of a debt, but particularly at point 4 you will see that the means by which it was proposed to apply the PAYG or ATO data, which comprised a PAYG summary, was to evenly distribute the PAYG data across all fortnights in the employment period. You see that?
Yes, I do.
All right. And it was said that we already apply this method as a last resort in the current process in circumstances where other sources of information were not able to be obtained, and it reduced, the proposal reduced red tape and complied with the Guide to Social Security Law, so it was said.
Yes.
2.2.3.
Yes.
All right. So that email was sent 24 April 2015, and you were followed up on the 1st of May, and you provided your response, which referred to a meeting in these terms: as long as the customer is given the opportunity to correctly declare against each fortnight and apportionment is the last resort, we support what you are doing. Good luck. So you accept that that email conveys that you understood, at least in 2015, the context in which you were being asked for your position on that as a person in the means test branch?
As I said, I don't have independent recollection of the full context of that. I accept what's written here, that was my understanding. In the context also of the timing of that email being post-consideration.
And you accept that even though, sorry to
process.
cut you off.
No, that's all right.
And you accept that even though you can't now recall that context or sending this email, the true state of affairs is that you did know in 2015 about the use of averaging as a last resort in terms of what was proposed at that point.
Yes.
We'll now take you to some documents for context. I take you to, now these are not your documents, and you may not have seen them before, but they might assist your recollection. Exhibit 6326, tab 10. The document is entitled PAYG Pilot Online Compliance Intervention Project Meeting Minutes. The date is 20 April 2015. There are various invitees, including Danny Scott and Tennille Collins. And if you go to agenda items, item 3, Roman numeral 2, dot point 3 and 4, it is said Danny Scott and Michael Lahoy to attend meetings with Debt Management, brackets Ben Dalton, Marjorie Reid, brackets, and Older Australians and International, brackets Emma Kate McGurk, to conduct PAYG pilot, brackets post-calc, bracket walkthroughs. Once the walkthroughs are complete, formal endorsement to be sought from both areas. You see that?
Yes, I do.
All right. I will run through a series of documents and then ask you if that assists with your recollection or prompts any additional matters in your mind. The next tab is tab 12. 2 days later, 22 April 2015. Oh, sorry, tab 12. Tab 11, I'm sorry, exhibit 6327. An email between a number of the persons who were listed as attendees on the previous document. The attachments are the Online Compliance Intervention Action Items Register and the Online Compliance Interventions Meeting Minutes, and a date is given for both documents as 20 April 2015. Please see attached for your review. If you turn then to tab 12, exhibit 6328, you will see the action item register. This might just take a moment. But while that's happening, you can see the
Yes, I can.
document in hard copy. On the action item register, you'll see that there are 10 items. Item 10, there it is an email to Debt Management Branch and Older Australians, brackets income tests, seeking written confirmation of principal agreement to PAYG process. The date is 24 April 2015. That's the column due date, column C. And the officer responsible is Tennille Collins. If you turn then to tab 13, you will see minutes of the PAYG pilot stakeholder meeting. The chair, exhibit 6329. The chair was Danny Scott. The person taking the minute was Mr. Lahoy. There were a number of attendees, including Ms. Collins. And item 3 was PAYG pilot updates. The first dot point related to Mr. Scott was a process walkthrough had been provided to Debt Management Branch and Older Australians and International Branch, brackets policy owners for income assessment. Walkthrough went well and in principle have agreement from branches with the process. Now, the reference to the Debt Management Branch and Older Australians and International Branch, that is a reference to you.
Just the Older Australians and International Branch.
And it's described as a branch which are the policy owners for income assessment.
I wouldn't have characterised it that way, but that's the way it is here.
All right.
We're just after one, Mr. Gregory, but if you think you won't be too much longer, maybe we should push ahead and...
Yes. I don't think I'll be too much longer.
All right.
And if you could turn to tab 14, Exhibit 6330. Although this is out of sequence, you'll see it's the Online Compliance Intervention and Detailed Requirements document. And if I take you to page 7 of 176.8457, you will see the template control document control table, which refers to the date of 1 May 2015 as the date the document was created, and the project senior responsible official was Scott Britton. See that?
Yes, I do.
If I take you to the page .8461, page 11 of 176, you will see that it's signed by Mr. Britton on 7 September 2015. Now, that was after you left the department on 22 June 2015.
Yes.
And if you turn to page 13 of 176.8463, and the previous page, my apologies for context, a business stakeholder list, and your name appears on the second page as having an involvement and responsibility relating to means test.
Yes, they have
Right.
updated it.
And to complete the sequence, I'll take you to tab 16, Exhibit 6332. The date of the meeting of the PAYG pilot project team was 4 May 2015. The chair on this occasion was Ms Collins. And project deliverables under the heading Agenda, Legal Advice and Policy, DMB and Means Test have provided in principle support for the PAYG pilot process. You see that?
I do.
Now, does that assist you to recall that the context in which you confirmed that averaging could be used as a last resort in 2015, that is on 1 May 2015, was in the context of providing policy advice or approval for the PAYG Online Compliance Intervention pilot?
No, I wouldn't have been in a position to provide policy advice.
What were you providing in your email?
Support, well, from what I can see, support for how they were implementing the process.
Right. From a policy perspective?
No, when I was in the Department of Human Services, the income support means testing team was not a policy team. The policy was the responsibility of the Department of Social Services. I would have been providing that advice. Certainly as I was saying before, the timing of it is post-consideration of the budget proposal where policy matters would have been considered. So I would have taken that as a given. And the income support means testing team was a team that was there to provide practical support to the network, program management advice based on the guide to the Act, but we weren't policy.
You weren't legal either?
No.
You were just providing support which doesn't fall under legal or policy advice?
Yes, that's
Is
correct.
that your position?
Yes, yes.
I suggest you well knew you were providing policy advice in support for averaging as a last resort for the PAYG pilot.
My role in that team, we weren't providing policy advice.
Was it program management advice?
Yes, it was. Yes, Commissioner.
And if you go then to tab 7, Exhibit 5639, you'll see that in March 2016, after you moved to DSS, you attended a DSS Payments Forum meeting,
Yes.
number 31, at which Mr. Britton from DHS attended
Yes.
and gave a presentation. You see that?
Yes.
If you turn to tab 8, Exhibit 5637, you'll see an email for context which attaches the PowerPoints for Mr. Britton's presentation at the DSS Payments Forum.
Yes.
And if you turn to tab 9, you'll see Exhibit 5638, CTH.3023.0003.5070, the PowerPoint slides for the presentation of Mr. Britton.
Yes.
And if you flick through to page 4 of your document, page .5073, you will see that this slide described the PAYG online compliance platform, and under the blue line, customer response, there are 2 or 3 shaded boxes, with yellow lines and blue lines. One goes to a computer, if that could be called out, that section. From MyGov and customer response down to the third box, thank you. And you can see that what was presented by Mr. Britton in March 2016 was that in circumstances where there was no action taken by the customer or they accepted the third-party data, there was an auto-assessment of the debt according to the customer's declaration. See that?
So you're talking about underneath the picture of the computer, this assessment does not change how income is calculated or debts are determined, that aspect?
No, I'm not talking about that characterisation. I'm talking about the scheme indicated by the shaded boxes and the yellow lines with an arrow to a computer.
Okay.
No action taken by customer or accept third-party data, and that leads to an auto-assessment. You see that?
Yes, I do.
And you understood that the third-party data was the ATO PAYG summary in this context?
Well, I don't have any independent recollection of this presentation, but from what I'm looking at this slide, yes.
And that in those circumstances, the calculation of PAYG data must necessarily be applied in an apportioned or averaged way to the relevant fortnights to raise a debt?
Yes, from that, yes. Can be inferred, yep.
You go to page 7.5076. The sticky note in the corner, which is the screen check your details, conveys that if you don't complete it in time, the information we have received from the ATO will be applied to your Centrelink record, and that's consistent with what is conveyed in the previous slide that I took you to.
Yes.
Yes, all right. Again, I suggest that there was no concealing of the fact by Mr. Britton that the process applied under the Online Compliance Intervention Program or its predecessor, the PAYG Manual Compliance Intervention Program, involved the averaging of ATO data to calculate debts. And you were aware of that fact as at 2016?
As I said before, I don't have any recollection of this presentation. I accept that I was in the meeting.
And do you accept that it clearly conveys that where a customer didn't respond or where a customer confirmed the accuracy of the PAYG data, averaging would be involved in the creation of debts.
I'm not sure I accept that it's clearly conveyed, but I understand what you're referring to, and certainly it could be inferred from the information in those boxes, yes.
Is there any other inference that you can think of which is conveyed by those documents that I've taken you to?
I suppose I'm focused on what I read out before under the auto assessment about there being no change.
Right. Right. But whether there was a change or not doesn't affect what was conveyed by the document that averaging was applied in those circumstances.
Certainly that's if you consider that and think about what it is, yes.
Yes. All right. So, Ms McGurk, I suggest that as at January 2017, when this issue about compliance with legislation and the accuracy of debts which were created under the scheme, you were well aware that DHS was applying averaging in those circumstances to create debts.
I have no recollection of that.
Can I take you to Exhibit 6376?
Sorry, which tab is that?
Yes, I'll just read this out for the document. Author CTH.3023.0021.7101. It is tab 22, Ms McGurk. Are you familiar with that email?
Only in the past hour or so. So prior to me coming in here.
Yes. And you can see that on Sunday, 15 January 2017, at about midday, you received an email from Mr Britton which conveyed your 1 May 2015 email in respect of the use of apportionment as a last resort.
Yes, I can see that.
Yes. And then you participated in a meeting with Mr Britton and others
Yes.
At about 3 o'clock.
Yes.
And it was not used to you at that meeting that averaging was being used by DHS, was it?
Well, at the time, I assume I had read this email, so in that meeting, I would have been familiar with this email, yes.
Yes. And it was not news to you that DHS was using averaging in respect of which you had given program advice in 2015?
During that meeting, yes, I would have been aware of this, the content of this email, which is what you just said.
Yes. Why didn't you produce it in response to either of the first notices that you were served?
I couldn't find it in my emails for the first or second notice. When this email was drawn to my attention only a matter of hours ago, I tried to search my online archives again and I can't locate it.
So you can't explain how this was produced by the Commonwealth?
Well, I expect it's been produced from Mr Britton's emails.
Somehow this one slipped through the cracks on yours?
I don't have a copy of it. There are a number of other documents where my name is that I don't have a copy of, so it wouldn't be the only one that I couldn't find.
And what you say now and what you said in November is that despite your 2015 advice being brought to your attention on the day that you met with Mr Britton and others in anticipation of a number of questions to be asked of both departments by the Ombudsman, you have no recollection of ever giving this advice?
No, I don't. The information I provided in my statements last October was almost exclusively based on the documents that I was reading and the notes I was reading. I had very little independent recollection that wasn't prompted by the emails that I found and my notes.
And you now accept, having read this document, that the circumstances in which you asked Ms Pulford to provide legal advice on the question of averaging as a last resort
Yes.
included the fact that you gave support for that process in 2015?
At the time, yes.
Right. Did you draw this email to anyone else's attention at DSS?
I can't recall.
Would be important to draw it to their attention, wouldn't it?
I can't recall having done so. There were...
The question is that it was important to do so. I don't feel able to answer for how I was thinking at the time, no. Do you now accept that you are, as you say, aware of the document? It was a relevant piece of information that you had gathered prior to the 15 January meeting.
Yes, I don't know that I didn't draw it to people's attention. I couldn't find any email where I appeared to have forwarded it, but given Mr Britton was part of those conversations, pardon me, it may have come up. I don't know. I don't recall.
Well, how do you arrive then at a recollection of averaging being something you weren't aware of when it was said to you in the meeting? That is, you can recall that impression and that information, when only hours before you received your own advice from a year and a half earlier, which provided support for averaging as a last resort. How could you have that recollection and that reaction in those circumstances?
So, as I said before, my statements were based on the emails that I found and on my notes. I didn't find this email and I didn't have access to my Human Services email when I did my first and second statements and when I gave evidence in November.
Yes.
It was to the best of my recollection as prompted by emails and notes.
Yes, but what you said in evidence was that this was the first you'd heard of it. That was the impression you had.
And at that time, it was the impression that I had.
But it couldn't have been because hours earlier you received this email in this context.
I don't recall receiving this email, and I hadn't been prompted to recall it when I was providing my statements back in October and providing evidence in November. Had I found it, my evidence would have been different.
You were telling me last November that you were new to this whole business,
Yes.
including averaging, and so was Miss Halbert,
Yes.
and you hadn't had any reason to think averaging was used to raise debts until you discovered it in 2015. And it was not a piece of information that you had before that meeting that it was being used as a last resort. Now, the most charitable thing you can say about that is it must be a false memory on your part of having those sensations in 2017, mustn't it?
So the evidence I provided was based on the information I had available to me. So in terms of false recollection, I was recalling based on what I was looking at. I had almost no independent recollection. So had I been asked to give my impressions without having looked at any of those emails and my notes, there's very little I would have been able to say. So the evidence I provided then was based on those documents.
But it was positive evidence that this was all news to you in January 2017.
Believed it was.
Well, as I said to you, at the very best, that's a false memory, isn't it?
It's an incomplete memory. Well, it's based on incomplete documents that created my recollection.
A false recollection.
Well, given these emails, there are things that I knew. I just don't remember that I was part of that at the time. In the same way that in providing my statements, there were things that I wouldn't have recalled if it hadn't been for seeing them in a document or in my notes. I wouldn't have independently recalled them.
What did you see that made you think you didn't know about averaging before this?
Before I saw this 2015 document.
Yes, what did you see? Before January 2017. What did you see that you based your evidence that it was a total surprise to you in 2017 on? What was the documentation that made you think, gosh, that was a surprise to me?
I suppose it was the absence of anything else, I imagine, and the fact that I couldn't remember anything else.
So you invented a memory? Look, would you please not... I don't want a sort of cheer squad at the back, please. Yes.
So all I can say is that the evidence I provided in my commentary in the statements was provided on the recollections I was prompted to think about at the time. That's the best I can say. Having seen these, I accept that there had been times where I had interacted on the matter before. I didn't recall them.
Mr. Gregory?
And yet you were able to recall a conversation with Mr Ryman in 2014 for which there was no documentary support.
I wouldn't say I remember a great deal of detail. I recall at the time that I received the information from Mr Joyce that I thought, oh, that was that thing that I'd had the discussion with Mr Ryman about. I didn't recall it in any detail. It just prompted a sense, a recollection. That's the best I can say.
Did either Ms Wilson or Ms Halbert tell you that they were involved in the advice to DHS in 2015 to the effect that averaging could not be used to calculate debts consistent with legislation?
I don't remember that.
If you went into the meeting knowing what you in fact knew about the policy and legal advice that you received prior to the meeting, and Ms Wilson and Ms Halbert told you that they were part of that advice, conveying that advice to DHS, that might be something that sticks in your memory, mightn't it?
I can't say because I don't recall if they said that to me or if they had, whether I should remember it or not. I don't know.
One view of the evidence, Ms McGurk, is that everyone in that meeting on 15 January 2017 was well aware that DHS was using averaging and had been doing so for a period of about 18 months since July 2015. What do you say to that?
Certainly post that meeting when the concept of last resort was discussed, we certainly understood after that. Clearly I had some understanding of that prior to that meeting, but as to Ms Halbert or Ms Wilson's understanding, I can't speak to that.
One view of the evidence of what followed that meeting was that yourself, Ms Halbert and Ms Wilson, agreed in one form or another to obtain legal advice from Ms Pulford, who was the author of the contrary legal advice in 2014, to provide a basis for what you had already advised DHS to do in 2015, that is, that it was okay to use income averaging as a last resort.
Sorry.
You predetermined the outcome of her advice and sought advice accordingly.
Well, we couldn't predetermine the advice that Ms Pulford was going to provide. We certainly, I commissioned the advice from her, asking her whether there was any legal basis for last resort.
And you must have done that knowing that you had given support for that concept in 2015.
At the time, having seen this email from Mr Britton, yes.
And one view of the evidence is that you have deliberately withheld this relevant email from the Commission in response to 2 previous notices and your 3rd notice, and gave false evidence about your knowledge of averaging in 2015. What do you say to that?
I disagree. I disagree completely with that. I was, as I said, my 1st and 2nd notices prompted by the emails I had access to. So I indicated this email from Mr Britton. When I became aware of it this morning, I again searched my online archive and I still couldn't find the email.
How were you provided with your emails for the preparation of your 1st and 2nd statement?
I wasn't provided with them. We have an online archive that I have access to my own emails. Other people did some searching, I understand, but I searched my own emails.
These are the DSS emails?
Yes.
And your only explanation for not being able to locate it is that the archive removed it somehow and you couldn't pick it up?
I don't know why it's not there.
But
I don't know why I couldn't locate it.
And what you're saying now is even aware of the existence of it, in your search of your own archive, it does not exist.
I couldn't find it.
And you knew exactly what you were looking for, date and time, and it's not there.
Well, I didn't know exactly what I was looking for. I was looking for any relevant documents for the time period, and I couldn't find this one. Having seen it, I couldn't find it. I looked again this morning.
Right. Yes, thank you.
Ms Hogendoren.
Commissioner, just one moment. Ms McGurk, in your first statement of 21 October 2022, apologise I don't have the exhibit for that to hand, but would you accept from me that paragraph 4 says this statement has been prepared with the assistance of officers from the department and lawyers, and paragraph 5 says in the time available I have made my best efforts to locate documents which fall within the scope of the NTG by searching my electronic records, emails and reviewing my notebook at the time. And having heard what you've just said in your evidence, do you confirm to the Commission that it was only you who undertook searches of electronic records for the purposes of the preparation of that statement?
So, primarily so. I was sent a number of emails from the task force, but in the department, but I had independently located those emails anyway.
Does anyone else have access to your archived email to your knowledge?
Well, any of my executive assistants or executive officers along the way, they have access to my emails.
No further questions, Commissioner.
Mr Beecham.
I don't have any questions for Ms McGurk.
All right. Mr Gregory.
The task force to which you refer, which department is that?
Department of Social Services.
And can you describe the role of the task force in the preparation of your first statement?
There was very little interaction. They provided me with the notice initially, and they indicated they'd done a search of some emails and provided me with those emails, which I said I also independently found.
And did you were taken to two parts of your first statement. First statement is Exhibit 138 at paragraph 13. You say, to prepare my response to this paragraph of the NTG, I have had regard to, and you refer there to emails that I sent or received during the period. You see that?
Yes.
Right. And in your second statement, Exhibit 148, at paragraph 5, you say, in the time available, I've made my best efforts to locate documents which fall within the scope of the NDG by searching my electronic records, brackets, emails, and reviewing my notebook at the time.
Yes.
Right. Thank you. Might Ms McGurk be excused?
Yes, you're excused. Thanks, Ms McGurk. Mr Scott, and that's you for the moment, Mr Gregory.
It is.
Mr Scott, are you ready to advance on this other argument, or do you need any more time? And Mr Varley likewise, I suppose? And I suppose Mr McCafferty might have an interest.
He does. I understood that Mr Roberts' lawyers had been notified that the public interest immunity hearing was to occur at 2 o'clock.
Oh, okay.
Yes.
Oh, well, that's all right. I don't mind going away and eating something. It'll be fine by me. So 2 o'clock then?
I think so, yes.
Okay. All right. Well,
Commissioner, just in respect of that, as I understand it, that will be a closed hearing?
yes, absolutely. And yes, just for the members of the public, it will be a closed hearing restricted to council, basically. And it won't be live streamed and it won't be recorded, except possibly by members of the Commission, but not in any other way, I don't think. That's right, isn't it? All right, 2 o'clock.
All rise. The Commission stands adjourned until 2 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
I have no further questions for Mr Robert.
Thank you. Ms Hogan-Doran?
I have no questions for Mr Robert either, Commissioner.
Mr McCafferty?
No questions, thank you, Commissioner.
Mr Scott, do you want Mr Robert excused?
Yes, please, Commissioner.
Thanks, Mr Robert. You're excused. Is that you? Oh, sorry, Mr McCafferty.
Might we be excused, please?
Yes, absolutely. Thank you. That's you for the day, Mr Robert?
It is, Commissioner. Mr Gregory will take the balance.
Right, thank you.
Commissioner, there was one matter arising out of Ms McGurk's evidence that I seek to raise.
Yes, I think Mr Gregory wanted to raise one matter out of Ms McGurk's evidence. Is it the same matter?
Probably the same matter. It will... it seems like he's happy for me to raise it. The Exhibit 6376...
Okay, do you want to wait for her to be here or...?
I was going to keep her outside and then raise the matters with the Commission,
Sure.
and then she can either come back in and give some more evidence or whatever.
I think, yeah, just tell me what you want to and then...
So it would be useful if 6376 could be brought up on the screen.
Mm-hmm.
Could I make the point on the record, Commissioner, that the first time we were given notice of this document was in a witness bundle given to us at 8:30 this morning. We had a hard copy at 10 when the Commission staff were kind enough to give us a copy of the witness bundle to look at.
Right.
Your Honour will... sorry, Commissioner, I think the difficulty is going to be with that is that No, I think we can still make the point. If I could ask
It can be called up, as they say, which is whichever bit you want highlighted, brought up.
It's the email address, emmacate.
Yeah, I've already had this pointed out to me, actually. That,
Yes.
what's the folio number for that? Do you know, Mr Gregory? And I'll turn up the document.
Tab 22.
It's the wrong address and it wouldn't have reached her, essentially, isn't
Right,
it?
so I'm not sure whether did you want to raise the feed? Okay.
I believe the live feed has been restored.
So
Mr Gregory mentioned it just before, having pointed out that he'd already mentioned it to the peer review. So,
well, we mentioned it to him.
well, whichever. Somebody mentioned it. So,
And we want to make 2 points, obviously. The first thing is that's the obvious reason it wasn't in Ms McGurk's email records when she searched them. She didn't
Yes.
get it. We have a copy of what we think is the bounce that Mr Britton would have gotten because of the incorrect email address, which we seek to tender.
oh, sure.
We only have a hard copy, but we've provided a copy electronically to the solicitors for the Commission.
Okay, 6378 then. Is that all right?
6376A.
6376 is the email, that email there.
63768, sure.
Thank you.
Commissioner, for the benefit of the record and for the provenance of that bounce back email, I'm instructed that that was searched for and identified by AGS solicitors over the lunch and adjournment and provided to my learned friends.
Right.
We then, there was a question put to Ms McGurk that she deliberately withheld the relevant email. We seek to have that formally withdrawn.
Well, I think if she gets the opportunity now and Mr Gregory, I'm not very keen on withdrawing things and rewriting history. Mr Gregory, I'm sure, will correct the record if she comes back to give evidence.
Right. In our respectful submission, Commissioner, the allegation was obviously wrong.
Okay, I'm sure Mr Gregory will say that.
In those circumstances, we also point out that she gave a series of answers on the premise that she had received that email, and those answers obviously now have no evidentiary weight, given that she premised them on having received that at the time at which the email bears.
Yes, I think they just were. I didn't find it, which is not surprising if it wasn't in her witness box. I don't think they're of much consequence. Otherwise, yes, all right.
There were a number of things that she did accept, knowing at the time of the 15 January meeting that were premised on having had this email in her possession. And we simply point out that she accepted that, premised on having accepted that she got this email.
All right. Okay, would you put that on the record?
Other than that, Ms McGurk is available if the Commission seeks to recall her and ask her any questions.
Yes, and I think that's the case, isn't it? I certainly would like to ask a couple of questions.
Yes.
Maybe you would, I don't know.
Yes, Commissioner, I've asked that she be available to be recalled in the circumstances.
All right, she's here, is she?
Yes.
Okay.
I don't think she's inside the...
No, she'll come through that way. I think there'll be somebody looking after her.
Thank you. Justin, that's the witness bundle. Oh, sorry. Thanks.
And Ms McGurk, I'm sorry to do this to you, but I think we'll have to get you to take another affirmation. That's what it was, wasn't it?
It was an affirmation, yes.
Okay.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right.
Thank you, Commissioner. Ms McGurk, you've caught up on events which transpired after you were excused.
I have.
That it was identified that in Exhibit 6376 behind tab 22, the last document on which I examined you,
Yes.
that there is a typographical error in your email address, particularly in your surname?
Yes, it's a Q instead of a G.
And although you accepted you received it based on my suggestion in the document, that was plainly based only on that rather than your recollection.
Absolutely.
Yes. You accept, I take it, and I do as well, that that provides a comprehensive or complete answer to why you couldn't locate it in your inbox.
Yes.
And in your absence, Exhibit 6376A was tendered. I'll just ask that you be shown a hard copy of the document. For the record, you can confirm, Ms McGurk, that that is a document which records that the email bounced back to the sender.
Yes, I can confirm that.
Thank you. I put to you that in those circumstances, you having accepted you received it and I having put to you that you did receive it, that you deliberately withheld the document in response to your first and second notices. Can I take it that your answer is that you did not do that because you never had it?
That's correct. I've never received the email.
And so there's no uncertainty about it. I no longer suggest that to you. You understand?
Yes, I do.
All right. Do you recall any conversations with Mr Britton on 15 January 2017 about whether, at all, communicating with him at all prior to the meeting?
Prior to the meeting, no.
That is, there are no other emails to your search which exist between you and him prior to the meeting?
No, and some searches were recently done.
When you say recently, please be specific.
Prior or post my evidence earlier today.
That is during the lunch break?
Yes.
Right. Thank you. And were there any emails after the meeting in respect of the question of averaging?
No, we couldn't find it.
Or any other topic arising from the meeting?
So, no, not to my knowledge.
Okay.
I mean, I have communicated with Mr Britton since that meeting, but and I think in my first in giving evidence before, there was a meeting that was in my notebook with Mr Britton, but it didn't go to this at all, the topic of this email.
Yes, those are the notes that are contained in the exhibit you produced in response to your first.
Yes.
To your knowledge, if you know, do you know what prompted Mr Britton and others within DHS to start sending you emails on this particular day?
I don't know specifically. I may well have been seeking information, but I don't know.
Do you recall speaking to Ms Alison McCann?
Yes, I have. I don't have, again, a specific recollection of any discussion with Ms McCann, but I'm certainly aware that prior to that meeting I'd had interactions with her, and you took me through some emails before that she had sent me.
In the context of you seeking information from her in preparation for the meeting?
Yes.
Yes.
It does look from this email as if you'd asked them to turn up things that DHS had which were relevant to you, though, doesn't it?
Well, I don't know if it was about relevant to me or relevant to the issue more broadly. I don't know.
All right. It just doesn't seem very likely you'd have lost all consciousness of what had happened when you were in DHS, and it's possible that you would have wanted any email discussion about what you had said or done on the subject.
I have no specific recollection of asking for any information relating to me and my interaction at Human Services. All I can think back to was that I was just trying to seek out any information that would assist in getting Ms Wilson and Ms Halbert across the matter. So I don't recall if it was specifically related to me or the issue more broadly.
Do you know if you got anything else from Mr Britton? Well, I suppose if you've looked for the emails, you haven't found them?
I haven't found anything else, no.
Okay, thank you. Anything?
Nothing arising from that, Commissioner.
Ms Odendoran?
Just in relation to that last exchange with the Commissioner, if you haven't got anything else from Mr Britton and you've looked for the emails, you haven't found any. You said earlier in your evidence there were a number of other documents where your name is on them that you don't have a copy of. Are you able to assist the Commissioner as to what those other documents were?
Not immediately. When I was flicking through very quickly, because I didn't have a great deal of access to this folder of tab documents, there was one in particular that I couldn't recall ever having seen before. But I would want to be fully sure and go back through all of my emails to ensure that that was the case. It wasn't, it was just in relation to where people were going to be for that teleconference on the Sunday. There was an email in there saying somebody was going to be in the office, and I don't recall ever having seen that email before, yet I'm on it. But that's recollection. I haven't gone through thoroughly all of my emails this morning to check whether I had missed it or not, but I don't recall ever having seen it.
That's all, Commissioner.
Thank you. Mr Beecham?
I don't have any questions in view of the very fair way that Mr Gregory dealt with that.
All right.
For the last time.
For the last time, we hope, Mr McGurk, you're excused. Thank you.
Commissioner, the next witness is Senator Payne.
Do you want to tender any exhibits just while we're waiting?
I'm told I tendered the full list.
Oh, okay. Yes, Senator Payne's exhibits are on there too, were they? Yes, they are. Thank you.
Thank you, Commissioner.
Counsel for Senator Payne? Sorry? Oh, okay. So how long are they going to take, do you think?
Commissioner, I understand Mr Arnott of Senior Counsel was appearing for Senator Payne. I have a contact detail for him if that would assist. I can try and track him down.
He's around. No, I think he knows. I think they're coming. But thank you.
Certainly this witness was given a not before 2:30 time.
Mr Arnott.
Commissioner, I appear for Senator Payne.
Thank you. Mr Gregory.
Yes. Thank you, Commissioner. Senator Payne is the next witness.
Yeah. Senator Payne, I don't remember if you took an oath or an affirmation last time, but we'll need you to do it again, please. So,
Certainly, affirmation, Commissioner.
okay, if you'd stand.
Response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Oh, take a seat, thank you. Yes, Mr Gregory.
Thank you, Commissioner. Senator Payne, when you last gave evidence, there were documents which either you did not have access to or the Commission did not have access to, or both. And as a consequence, you were served with a notice to give evidence and produce documents, notice to give a statement and produce documents, NTG-0160, and you produced a third statement in response to that notice, dated 21 February 2023. Can you confirm that?
Yes.
Thank you. The first topic to which documents relate since your previous evidence is the question of the extent of your knowledge of the contents of brief B1539. I understand there is a bundle before you, and I will take you to tab 5. It is Exhibit 5207. An email, again, not involving you, but involving Ms Lees, your Chief of Staff, which refers to the Secretary, that is Ms Campbell, being very keen to get that in front of you, to give you as much time to consider it before the meeting on Tuesday. That was the meeting scheduled for Tuesday, 20 January 2015 at the Parliamentary Offices in Sydney. Is that correct?
To best of my recollection, without my diary in front of me, yes.
Yes. And the request was from Ms Ridderhoff to Ms Lees to provide a copy to you tomorrow morning. The attachment is behind tab 6, and it is Exhibit 5208. Can I take you to page 11 of 26 of that document ending .0161? This is the first time the proposal was put in writing and indeed put in a brief which was said to be delivered to you. The detail contained under the heading Potential Priority New Policy Proposals, one PAYG cleanup, contained a number of factual matters. As you can see, the first points that I'll take you to are paragraph 1D. The proposal will provide for a 4-year measure to undertake 866,857 interventions for customers at risk of undeclared or underdeclared income from employment. It is anticipated this would result in an estimated 1.2 billion gross savings and debt due to returned outlays. If I pause there and defer the question of whether you have any recollection of seeing this document specifically, or accept that you do, from your review of the documents, do you accept that the concept of a 4-year measure involving that number of interventions and the estimate of 1.2 billion gross savings and debt due to return to outlays did not substantially change in various versions of the brief that you were provided with or were provided with for provision to to Minister Morrison, or were contained in the new policy proposal presented to the ERC?
Broadly speaking, those numbers remained similar.
Yes. Paragraph 1B referred to the way in which interventions would be undertaken. And what is said in this document is that the customer would be presented via their online account with the information from the ATO and an assessment of their correct welfare entitlement based on that information. The assessment will use an income smoothing methodology to apportion the customer's income over the time of the employment brackets rather than the current cumbersome process whereby the department has to determine and apply income on a fortnightly basis. And it continues. As at January 2015, you understood the concept of the entitlement to welfare payments based on fortnightly income, that is actual fortnightly income, for a majority of payments.
So, Mr Gregory, this is 8 years ago.
I understand that.
And speaking to my exact recollection of the arrangements 8 years ago is difficult. I can't say that that was my exact recollection at the time, but obviously have read multiple documents in relation to these hearings which affirm that.
Thank you. And did you appreciate, well, do you now appreciate, in light of your inability to recall specifically, that the proposal retrospectively adjusted the entitlement calculation? That is, it did it by the averaging of income over a broader period rather than the ascertainment of actual income during the fortnight, relevant fortnight.
I'm not sure I can say that, Mr Gregory, in terms of my recollection of the specifics of these processes, these discussions and these documents.
Okay. Having reviewed the documents that have now been brought to your attention, do you accept that you saw this document? It was provided to you?
Again, I don't have a specific recollection of it, but based on the calendar and other information, including emails between others, not involving myself,
yes,
that would seem to be the case.
All right. Can I take you to tab 8?
8, yes.
Exhibit 5210. Again, is this one of the emails to which you just referred that allow you to reach a position where you accept you were shown the B1539 document?
Yes, I don't recall the specific email, but it does do that, yes.
Yes, all right. And the Commission's heard evidence that Ms Bratuza is, or was rather, an executive officer for you?
Effectively, yes.
Yes. Right. And the reference to CPO is the Commonwealth Parliamentary Officers in Sydney?
Yes.
While we are on the attachment, or if we move to the attachment behind tab 10, we keep working our way through the tabs. At page 11 of 26, you can see the relevant part of the document, Exhibit 2501. CTH .3784.0001.0004 at page .0014. This document in this form at page 11 of 26 at dot point E identifies that there may need also to be a change of legislation. I'll quote it, it may also need to change legislation. You see that?
Yes.
Thank you. The possibility, which is indicated by the word may, in this version of the proposal, was converted to a need to change legislation in the executive minute, which was forwarded to you for information and to Minister Morrison for action 12 February 2015. I can take you to the specific part if you would like.
Which number?
Tab 24. Exhibit 2669.
I have, yes. This is 15125?
Yes, it is.
Okay.
And if you turn to page 10 of 17.0046,
Yes.
You will see in the last paragraph the may is removed and replaced with a firm statement for the need for legislative change to implement the initiative.
Yes.
All right. And although you may not specifically recall it, do you accept now that that reflected ongoing discussions between the departments of Human Services and Social Services in respect of the executive minute, or the proposal contained in the executive minute?
As I think we discussed on the previous occasion, Mr Gregory, the advice in a number of briefs, but certainly in one specific brief, was that DHS and DSS would continue to work on these matters. So yes, that is my expectation.
Yes. And on the front page of that document, to refresh your memory, you'll note that then Minister Morrison signed the document on 20 February 2015.
Yes.
Which you may take from me was a Friday. Can I take you then to tab 24B, Exhibit 5223. This is not an email to which you were a party. It is an email between various persons within the Department of Human Services, ultimately including Ms Campbell. However, the relevant passage is the email at the bottom of the page, Wednesday, 25 February 2015, and over to the following page, which indicates the timetable for the Department of Social Services portfolio budget submission, preparation, exposure drafts, coordination versions and the like, and that the exposure draft version of the portfolio budget submission was then scheduled for Tuesday, 3 March 2017, with a view to consideration by the Expenditure Review Committee on Wednesday, 18 March 2017. Now, as is evident from other documents that you've seen, the Expenditure Review Committee in fact considered the DSS portfolio budget submission on 25 March 2017.
Yes.
And the development of the new policy proposal relating to the PAYG measure commenced relatively soon after Minister Morrison signed the executive minute. Undoubtedly with a view for a confined timetable. I might take you to a particular document then, I don't want you guessing. It's right at the back, Exhibit 5526, tab 71. So the second last and last tabs. Again, these are not emails to which include you. They are within the department, and it is a week after Minister Morrison signed the executive minute, and there is a discussion between two people within the department about the latest version of the draft NPP. And again, there's no suggestion you saw the document, but I'm indicating the timeline to you.
Thank you.
tab 72 is the attachment, Exhibit 5527. Generally speaking, a draft of a new policy proposal is not a once and for all document. It goes through various drafting and redrafting stages even before it makes it to the exposure draft release, according to your experience.
That's correct.
Yes. The passage I want to take you to particularly is page 3 of 6, .5381_R_0002. And the second paragraph commencing the new approach. Do you see that?
Yes, I do.
All right. And you may not have had much, if any, opportunity to review this document before your evidence, so please just take some time to read that passage if you like, or the whole of the document if you would like.
Mr Gregory, I don't recall seeing this marked up document previously. I may have, but I do not recall it.
All right.
And I don't recall seeing it recently either.
Right. But there's no document indicating it was brought to your attention, but it will be relevant to questions I asked you about what happens within the department now that you know that it exists. You can see that the redrafting inserted the words, the new approach will not change how income is assessed or overpayments calculated, and deleted the words, this assessment will be based on the fortnightly attribution of the income advised by the ATO, equally distributed over the duration of employment for the period the customer was on payment. Seeing that now, do you appreciate or do you understand that the way in which the document, the draft of the NPP came to you involved a change reflected in that paragraph between what was contained as a concept in the executive minute, the apportioning of income on PAYG data, to an assertion that the new approach would not change how income is assessed or overpayments are calculated?
Yes, I can see that there were changes through the progression of the documents as they were provided to ministers, yes.
Can I take you back to tab 30? Sorry, Senator Payne, can I take you firstly to tab 25? The date is Tuesday, the 3rd of March 2015. And the email, Exhibit 5230, the email is from Ms Canning within the department, the Acting Chief Financial Officer, to Ms Lees, attaching the NPP appears to be version 8, according to the attachment header. And Ms Canning sought confirmation from Ms Lees, according to the second last sentence, in respect of clearance for the NPP, so that the information could be provided to the Department of Social Services.
Yes, I can see that email.
Yes. And that the attachment, Exhibit 5231, is the first draft that appears to be sent to your office. And at page 3 of 6.0129, you will see the relevant paragraph, relevant in the sense of the version of the one I just took you to,
Yes,
just above the redacted portion in the centre of the page,
yes.
which contains similar numbers, although it provides a variable where debt and savings might be estimated. It contains the assertion that the new approach would not change how income was assessed or overpayments were calculated.
Yes, I can see that paragraph.
Can I take you then to tab 27? An email of the same date from your Chief of Staff to Ms Canning, and you can see that it's less than 15 minutes, I think, after she receives it, and confirms that the text and the NPPs for all savings measures can be sent to DSS. Do you accept that that reflected an approval by you, or in respect of the clearance sought in the previous email for the measure to be forwarded to DSS? That is that draft.
I think I say in my statement, Mr Gregory, that I don't have any specific recall of that morning, those 15 minutes specifically 8 years ago, as to whether I did, but I do know that Ms Lees would have ensured that she checked with me that they should be forwarded. So I can't say whether I saw the material and it was forwarded, whether it was checked with me and forwarded, but I'm sure Ms Lees would have checked with me.
And in terms of the sequence, can I take you to tab 33? Exhibit 2563. Again, still Tuesday, 3 March 2015, Ms Lees sends an email to Mr Wan, who was then the Chief of Staff for Minister Morrison, which attaches version 10 of the NPP. Pausing there, are you able to speak to the ordinary course of the provision and of the MPP between ministerial officers in the circumstances where you were the Minister for DHS, who had developed the NPP, and Mr Morrison was the Minister for the Department of Social Services, whose responsibility it was to bring forward the NPP in its portfolio budget submission? It appears that, to give you some clarity about what I'm asking, it appears that in addition to what is being sent between the departments, there are copies of the NPP being sent between the Minister's offices. Is that the ordinary course?
It depends, I think, Mr Gregory, on the circumstance, and each one may be different, but there would be a possibility that certainly they would be exchanged between officers, particularly given that I was a junior minister and the senior minister, the cabinet minister, is the minister that takes the NPPs, but the portfolio budget submission through the Expenditure Review Committee process.
Yes, thank you. To continue with the explanation of the chronology, can I take you to tab 38A? Exhibit 5243. Again, you are not a party to the emails, but they indicate what was happening at departmental level within the Department of Social Services. And the email at the top refers to Ms Donegan, who we understand worked in Minister Morrison's office, that DSS was good to go out with the portfolio budget submission for exposure draft. Do you recall, and if you don't, do you accept, that you were provided with copies of the Strengthening the Integrity of Welfare Payments NPP in the course of the exposure draft process and the coordination draft process?
I don't have specific recall of either of those periods, but based on the material that I have seen, and I've not seen this email at all before, to the best of my knowledge, based on the material that I have seen, yes, that would have been the case.
Can I take you to tab 39, Exhibit 5245. For context, it is an email between persons within the Department of Social Services which conveys a position of the Minister, which is, of course, Minister Morrison, requiring a copy of the exposure draft version of the portfolio budget submission to be delivered to him in hard copy urgently. And the attachment, or one of the attachments of that exposure draft is behind tab 40, Exhibit 5246. Which, if you turn to page 169 of 269, ending .1832, you will observe some formatting changes to the relevant paragraph above the redacted portion in the centre of the page, in that it's a dot point, but otherwise no change of substance for the NPP in the exposure draft to the one which was sent to Ms Lees and cleared by you the previous day.
I don't recall the exact formatting, but I'll accept that, Mr Gregory, take your word for that.
Can I take you to Exhibit 5253, tab 45A? Ms Lees is a party to this email and it refers to you. An email of 10 March 2015.
Mr Gregory, I'm sorry to interrupt, but that's not what's at 45A in my folder. There's another copy of an NPP there, not an email.
Can I ask you to turn to the next page?
46?
Yes.
Yes.
Is that the...
That is an email.
Is it the one that is on the screen?
No. No.
You
want me to work
I've
from
got
the
it
screen,
at
Mr. Gregory?
45B, if that's any help.
45B, Commissioner?
B, 45B? You haven't got that?
No.
Well, I can hand you my copy if it'll make...
The one on the screen?
You happy with that? Okay.
Well, yes. Okay.
The email contains information about the exposure draft process leading into the coordination draft process for the revision of NPPs, and particularly this one? And does it confirm that as part of that process, or are you able to confirm, having read it, that as part of that process you reviewed the exposure draft of the particular NPP and cleared it for the coordination draft?
I don't recall that 8 years later, and I'm sorry, Mr Gregory. I can't confirm from that, particularly given it seems to me to be a statement of, as you say, timing, program, well, process, not program. But I'm not sure that I can respond to your question specifically. I don't have that recollection.
All right.
8 years later.
Thank you. Can I take you to tab 50A?
50? Yes.
And I'll also take you to tab 50B. They are exhibits 5256 and 5257.
Yes.
The first, which is later in time, 5256, is an email from Ms Lees to yourself on the 11th of March 2015, which refers to the compliance NPP, which was on the way, and some references to the position of Prime Minister and Cabinet and the Department of Finance in respect of the NPP, and a note that DHS will prepare fighting points on this for ERC. On the off chance that you do have a recollection of the fighting points prepared for this ERC, I'll ask you to speak generally. In your experience, what is the purpose of fighting points for the ERC?
I don't recall these specific instances, Mr Gregory, but it would depend on the circumstance. Again, the statement in this email says Finance is wanting the Department of Human Services to absorb the spend items. Fighting points, in inverted commas in my parlance, would be to defend the position of the Department of Human Services against that finance position, and to contrast those with talking points in the broad drafted in support of the particular proposition that the Cabinet Minister and other ministers are advancing.
Thank you. The next document, 5257, attributes to you, again, you're not a party to the email, attributes to you that the revised Department of Human Services new policy proposals were signed off by you and are now with DSS as at that date. Again, I take it you have no recollection of doing that.
Not specifically, no.
But that the process occurred in the ordinary course of exposure and coordination draft comments in preparation for the Expenditure Review Committee consideration of the DSS portfolio budget submission.
For those matters that pertained to human services, yes.
Yes, that's right. Can I take you to tab 52? This is only for the timeline. Sorry, 52 capital D. It is an email to various persons. You may simply note Mr Pratt, the Secretary of the Department of Social Services, Ms Wilson, his Deputy Secretary, and Mr Charles Wan, the Chief of Staff of Minister Morrison, and the attachment refers to the coordination comments draft of the Social Services Portfolio Budget submission, and the date is 18 March 2015, indicating at least by that point, but probably earlier, the schedule that was anticipated in February for an ERC consideration of 18 March had been pushed back.
Yes.
Thank you. On that date, your diary, that is your calendar, reflects an entry for a meeting with Ms Campbell behind tab 53A. It is MPA.0001.0001.0099 and simply reflects a weekly meeting between between yourselves, as was the ordinary course between you and your secretary.
That would be my understanding.
All right. Behind the next tab, 53B, MPA.0001.0002.0006, there is a handwritten diary entry, which I understand is your handwriting.
Yes, that's my handwriting.
And was the budget submission discussed with Ms Campbell on this day?
Those notes on about the sixth line say, if I can decipher my own writing.
Thank you, yes.
Budget subs dash DSS, comma, measures visible but not much narrative, full stop, question mark, NDIA, and whether possible, that would mean, by 1 July 2016, semicolon, and the next line, dash PB sub circulation. I take that to mean portfolio budget submission circulation. And then over the page, Medicare compliance dash where it fits, question mark. I think the rest of it does not pertain to the portfolio budget submission. They are other matters.
If Ms Campbell raised with you a remaining question about the legislative basis on which the PAYG measure was to be introduced, during that meeting, would you have made a note of it?
I don't think I can say either way, Mr Gregory. That meeting probably spanned an hour. That would usually be the normal course. There are very brief notes in relation to that. I have no specific recollection of this meeting 8 years later or of how long it took, and I don't think I can speculate as to what I would have annotated and what I would not.
You say in your statement that it was not unusual for matters which required legislative change, or not necessarily unusual for matters which required legislative change, to be put before an expenditure review committee for consideration in respect of a budget or mid-year economic and fiscal outlook.
Yes, I did say that in my statement.
Do you say that in the context where, if there is a need for legislation, it is identified prior to the ERC's consideration of the proposal? That is, you would expect everyone to be aware of that fact before it's considered by the ERC.
I don't think you can generalise in relation to that. I can only speak from my own observations. The submission, the brief that is numbered in the DHS numbering, not in the Commission's numbering, 15/1539,
yes,
which has multiple components to it, includes many references for other proposals that would require legislative change as well. So it is a matter of each proposition being handled on its own merits is how I would describe that.
In the cases that you refer to in that brief, the need for legislative change, I think, is identified for a number of measures.
That's right.
On the face of the brief.
Yes, it is. That's what I was saying. I'm sorry if that was unclear.
No, that's okay.
Not related to this, by the way, not related to this subject, but on other matters.
Yes, what I'm getting at is that in the circumstances where the Expenditure Review Committee are considering a new policy proposal which requires or might require legislative change, that fact or that possibility ought be identified in the ordinary course as part of the information put before the ERC for their consideration.
I still think, well, I would restate what I said before, that each circumstance is unique, that I don't have any access to material to tell me whether that was the case for those other propositions in B1539 or not when they came to the ERC. I don't have that material. And as I said previously today, the briefs that came to me in a number of places indicated that the Department of Human Services and the Department of Social Services were continuing to work together on these matters, which is my expectation as a minister.
For completeness, the electronic diary entry is Exhibit 6370 and the handwritten note on the screen is Exhibit 6371. The documents which you were not also aware of and had not been tendered before the Commission prior to your evidence on the last occasion include those relating to the consideration of the Expenditure Review Committee of the DSS portfolio budget submission on 25 March. Can I take you to tab 61, Senator Payne? Exhibit 2507A, and confirm with you that when you gave evidence on the previous occasion you did not have this document available to you.
That's correct.
And it records your name in respect of the second revised business list for item 5A for the ERC on 25 March 2015.
Yes, it does.
And if I take you back to tab 59, Exhibit 2507, this is the attendance record for the ERC on 25 March 2015, and asked you to confirm also that you did not have access to this document which records your attendance together with that of Catherine Campbell for item 5A on the revised business list.
No, I did not have that previously.
Thank you. And the next document was, of course, the MVP considered by the ERC on that date behind tab 62, Exhibit 2022. And attachment A3 to the DSS portfolio budget submission is contained there from pages 20 of 364 through to 27 of 364.
Yes.
Having now been made aware of those documents, did that prompt any recollection that you attended the ERC when the measure was considered on 25 March?
Not specifically, no, but it is clear from the record that I did.
If I take you to page 22 of 364, PMC dot... Actually, won't help. Exhibit 2022, page 22 of 364. In the second half of the page, thank you. You can see the description of the measure as presented to the ERC. And again, the number of interventions, I think, becomes the number of customers in the second of the three sub-dot points. But otherwise, the description of the process in respect of the 2010, its application from the 2010 to 2013 financial years, and the question of historical non-compliance are much the same as were considered in the brief B1539 and then the executive minute to Minister Morrison.
I haven't done a paragraph for paragraph comparison, but broadly speaking, yes.
Broadly speaking. And it remained, according to this document, the targeting and the first sub-dot point, the targeting of discrepancies on the analysis of the PAYG file obtained from the Australian Taxation Office. Did it occur to you at any point between the point at which the executive minute was sent to Minister Morrison and copied to you on 12 February 2017 and the provision of the first version of the NPP seen by you on or about 3 March 2017, that the change from the concept of a new approach, which did change the way in which income was calculated and entitlements were assessed, or debts were assessed, raised a question of how that might occur in practice?
Mr. Gregory, not that I'm able to specifically recall 8 years later and through many more of these processes subsequently in other ministerial roles, no. I cannot recall that.
In the absence of any recollection of that question coming to your mind, are you able to explain from your review of the documents now how that process could be implemented, the PAYG process could be implemented in a practical sense, in the way in which it was first proposed, as we now know it was, but without the consideration of the question of the need for legislative change?
No, I don't think I am in a position to explain that now. I would need to equip myself with appropriate material to do that.
And what would that be?
I'm not sure, Mr. Gregory. I would have to look at the question that you've asked and determine what I needed to understand the application. Some significant period of time afterwards, I don't have the specifics of the legislation. I don't have the specifics of the process front of mind.
One of the questions which confronts the Commission in respect of the change made, I think, on 27 February 2015 in respect of that draft, which was not seen by your office, is whether simply the words were changed in order to get the measure through the ERC because of the value of the measure to the budget. Are you able, in your experience, to comment on that possibility? That is, at departmental level, they changed the words but didn't change the nature of the measure.
That is not a proposition that I have encountered before and not something that I would envisage public servants doing. I would expect to get advice as a minister in relation to these matters if the view of my department was that they needed a ministerial view or a ministerial response on such questions. There was not advice provided in relation to specific legislative or policy change in any material that I have seen as specific brief on that matter. And to use a colloquial turn of phrase, there was not a red flag or a stop sign placed in front of me to the best of my recollection.
There appears to be, in the documents at least, a positive assertion that no legislative change is required from about 26 or 27 February 2015 onwards, which was presented to your office at least by the 3rd of March. Do we take it from your evidence that the explanation for you having no recollection of how that might have come about is because you were satisfied that whatever legislative and policy issues were identified in the executive minute must have been resolved between the departments?
I wouldn't characterise it like that, Mr Gregory, but I would say my expectation was where I was told in material presented to me that the Department of Human Services and the Department of Social Services, and told on more than one occasion, were working together on this initiative and the many others that were part of this NPP, that work was being carried out.
And given the form in which the NPP was first presented to your office on the 3rd, in similar terms to what appears in the final version on the screen, you don't consider that any obvious question arose or arises on your reflection of the documents about how the measure might be implemented?
I don't think I said that, Mr Gregory. I said I don't have a recollection of the specific period and these specific matters that we are discussing. I am endeavouring to assist the Commission with the material that's been provided to me.
Are you able to say that if you were provided with any assurance that the legislative and policy question had been resolved, it was firstly not in the form of any formal brief to you, such as the template of B1539 or a similar template?
I don't think I said I was provided with any assurance. I said I don't recall.
That's right. I'm just eliminating possibilities that you were provided, it didn't come in the form of a formal written brief.
No brief that has been identified by your processes here at the Commission and provided to me, no.
All right. And there's no record that you were able to locate of any assurance given to you orally by Ms Campbell, Ms Golightly or anyone else within the department in respect of that question?
Again, in terms of the material that I've endeavoured to locate for the Commission, including going through notebooks, etc., none of those notes are relevant to that matter or even record that matter.
And so it appears to be the case on the documents as they exist that the question of policy and legislative change had dropped off the table somewhere between 20 February at least, when Minister Morrison signed the executive minute, and the 3rd of March when you cleared the first draft, which asserted that there was no change to the fundamental calculation of income or the assessment of debts.
There is no material that tells me either way, but except for the change in the wording in the separate documents. And I do not have a specific recall, as I said, 8 years later.
Thank you, Commissioner.
Is that it? Mm-hmm. There are two possibilities that might spring to your mind in that situation. One is that the proposal had changed, and the other is that there was some idea that there would be legislation, but there's no other possibility, is there?
I'm not sure I understand your question, Commissioner.
Well, they'd said this proposal, because it involves averaging, and you understand we're talking about the PAYG proposal, will require legislative change and possibly policy change. That's what the executive minute had said.
Yes.
And then you get an NPP which says nothing on the subject of legislative change and now says it's not required. So something's got to have changed. And It doesn't seem to have been legislative change, so did you have no recollection of inquiring as to what resolution had been reached between DHS and DSS?
Commissioner, in the preparation of the DSS portfolio budget submission for the 2015-2016 budget, as I think we discussed on the previous occasion, there were upwards of 40 new policy proposals, a number of which pertained to the Department of Human Services. But I don't have specific recollection, no, of this one, given the amount of time that has passed since, which is 8 years.
It was going to bring in $1.4 billion over 4 years and affect involve 866,000 interventions and some hundreds of thousands of customers. You don't recall how that was going to be achieved?
Commissioner, through the number of policy proposals that are advanced in that executive minute, I think it's called 1539. There are many in there. As I said, there's more than 40, including others of significance in the entire portfolio budget submission. But I don't have specific recollection after 8 years of these sorts of matters that you're asking me about now.
Okay. Well, the evidence seems to be that, in fact, nothing changed. The proposal went ahead, as it had always been planned to do, involving averaging. That's your department's doing, and somehow it got past you, it seems.
The proposal that was taken by Minister Morrison to the Expenditure Review Committee is the one that is in front of me here, redacted, of course, as part of that whole portfolio budget submission. That's correct.
And what your department did was to make the assertion that there was no change to the way income was calculated or debts raised. But in fact, it wasn't true, because they were going to apply averaging on a default basis for anybody who didn't respond or was fool enough to say, yes, that's my annual income. So that was a change, and it did occur, but all of that went through without your appreciating that it was happening, or?
Well, Commissioner, I have endeavoured to respond to the best of my recollection and the best of my knowledge now. I don't have a specific recollection of the engagements on this single NPP amongst the many others, and certainly 8 years later, following multiple other budget processes, multiple other NPPs through that time.
Okay, just bear with me a minute while I check something, but Mr Morrison's evidence seemed to indicate he always understood that this proposal involved averaging of income. His position was that that was fine, it had always been done. Did you have an understanding of that kind?
I think I said to Mr Gregory earlier that I can't speak to my specific recollection of my understanding 8 years ago. I was the junior minister in the portfolio to the senior cabinet minister who was advancing the NPPs and supporting that process, including for those NPPs that directly affected my department. I'm not sure the right turn of phrase. The material that appears in the NPP reflects broadly my understanding of the process that would be taken.
But there's very little in the NPP about the PAYG measure. It leaves out the averaging bit, which was a feature of the executive minute. That just didn't strike you, or?
I think I've tried to answer that question, Commissioner.
All right. Do you recall any discussion with Mr Morrison about the measure?
No, I don't.
Okay. Do you recall being briefed by anybody from your department about what was now involved?
Not specifically, and there is no record of such a briefing that I have been able to obtain, or to identify, I should say, in my notebooks or in my calendar on that specific issue. Broadly, on the portfolio budget submission, which we've discussed with Mr Gregory.
Okay, thank you. Anything arising?
Just on the question of your position as a junior minister to the Cabinet Minister, you're talking there about the line between Cabinet portfolio responsibility and your role as a minister for the department within the portfolio.
Yes, but I also was not a member of the Cabinet, so I'm a junior minister by definition.
Yes, but that didn't affect your ability to have input into the drafting or the content of the NPP generated by your department?
No, it doesn't affect the ability to have input, no.
Right. Thank you.
Ms Hogan-Doran.
No questions for Senator Payne. Thank you, Commissioner.
Thank you. Mr Arnott.
No questions, Commissioner. Thank you.
Right.
Yes, if Senator Payne could be excused.
Yes, thanks, Senator Payne. You're
Commissioner, thank you,
excused.
Mr Gregory.
And I think we may be adjourning. Did you have anything else?
No, I don't.
All right, we'll adjourn till 10 o'clock tomorrow.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.